Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 20-1429 et al. Xcel Energy Services on behalf of its public utility affiliate, Southwestern Public Service Company, petitioner versus Federal Energy Regulatory Commission. Mr. Lowell for the petitioner, Xcel Energy Services, Inc. Ms. Kimmel for the petitioner, Kansas Electric Power Cooperative, Inc. Ms. Pasella for the respondent, Mr. Binet for the intervener, Southwest Power Pool, Inc.
Good morning, Council. Mr. Lowell, please proceed when you're ready.
May it please the court. My name is Joseph Lowell. I'm attorney for Xcel Energy Services. Here today presenting the arguments of the petitioners regarding the tariff interpretation of attachment Z2 by FERC in this case.
Could you try to speak up just a little bit, please? Thanks. You can also switch to raise the podium, but I think it's okay.
Okay. Your Honor, this case concerns attachment Z2 of the SPP tariff, and attachment Z2 sets forth a process for determining cost responsibility for the use of creditable upgrades, which are a type of transmission upgrades that are directly funded by a sponsor. The standard of review in this case for this issue is the arbitrary and capricious standard. When on questions of tariff interpretation, this court will review the FERC's tariff interpretation, will review the tariff language to determine whether it's ambiguous or not. If it's unambiguous, it will apply the unambiguous meaning. If it is ambiguous, this court will defer to FERC's interpretation if it's reasonable. Moreover, FERC's interpretation must be supported by the record. If we look at the provisions at issue in this case, in attachment Z2, the first key relevant provision of attachment Z2 establishes a rule for who is responsible for paying these revenue credits. And it states that revenues for credits will be provided from new long-term network integration transmission service that could not be provided but for one or more creditable upgrades to accommodate the service.
Mr. Lowell, one of your arguments is that the N1 contingency analysis is the industry standard here for calculating something like for upgrades. So what is your evidence that this is the industry standard for that?
Well, in our
especially when we're talking about not calculating things ex ante, but ex post, where this method seems to be very difficult to implement.
Well, so the articulation by FERC that it is only that the N-1 test is only used for initial determinations of upgrade responsibility, as you said, not ex post. That is a new concept that was announced in this order. We have cited to the precedent that traditionally the but-for test to implement that type of requirement, you need to do an N-1 analysis.
Oh, so your friends on the other side say that using that method would essentially be so difficult that the petitioners here would end up not paying any upgrade credits because it would be so difficult to calculate under this method. What is your response to that?
Well, I have a few comments to that. First, we did argue that the industry standard and FERC precedent traditionally would use the N-1 test to implement the but-for language in the tariff. However, even if it were the case that the N-1 tests were too difficult as a method of implementing that language, there may be some other approach that might work, but it would need to still satisfy the condition. It would still need to demonstrate that the service could not be provided without the upgrade. So ultimately, it's what's in the tariff, I think, that governs.
Do you know what does the implementation of Rule 2? Because as I understand it, Rule 1 deals with flows that are in the same direction as the one that gave rise to the need for the upgrade.
Mm-hmm.
But if you go in the opposite direction, the way that the methodology is set out does something more than what happens under Rule 1, because under Rule 1, everyone who uses the same direction is on the hook. In the opposite direction, not everybody is. It's only if the upgrade made possible the use of the opposite direction.
Well, they use some simplifying assumptions. Yeah, you're correct. So Rule 1, if you exceed the 3% threshold PDF factor, you're deemed to be using the upgrade under that reservation stack analysis. Rule 1. Rule 2, they're assuming that they take a look at what the capacity of the system was there before and what the flows are, and then they assume that there is they calculate a limit and then try to assume that once you exceed that threshold by stacking transactions going in the reverse direction, that they are then, once they pass that threshold, now using that.
Do you have any issue with the way Rule 2 is implemented?
We do. So as our expert explained,
On the basis that that doesn't qualify as but-for?
well, that it doesn't implement the tariff language, which requires that the service can, if the service could be provided without the upgrade, customers shouldn't have to pay again because we're already paying for the cost of the transmission system. If you're only looking, since we're talking about an electrical circuit and the flows go where they will, but they generally follow a path of least resistance. If you're only looking at the impacts on this creditable upgrade and as a way to infer what's happening for the capability of the rest of the circuit to accommodate our flows, we think that's simply invalid. That's employing, we think, a incorrect assumption, and it will not determine whether or not our service could be provided without the upgrade.
But at least the way Rule 2 is articulated, it seems consistent with a but-for goal. It may be that in pursuit of the but-for goal, there's something going on that's awry in the way that you're describing it. But
I think I agree with you that in Rule 2, they are attempting to do more, that there is an attempt to do some sort of causation.
whereas in Rule 1, your view is that there's not.
Rule 1, yes. Correct. But as I said, on Rule 2, we still don't think that that would comply with the tariff. To just look at the impacts on that particular credible upgrade.
And then can I ask you about one statement in your brief?
Sure.
So, gotten some attention in the briefing, but on page 57, and this goes to some of the arguments about whether the challengers have received adequate notice of the costs. And the brief says the service agreements could have said that it is unknown at this time whether particular upgrade costs will be assignable to the customer, but they did not, which I read to mean if the service agreements had just said it's unknown, that would be fine. And if that's true, then why does it matter that the tariff might be articulated at a high level of generality such that you don't have the direct ability at that point to discern the precise level of costs and you may be on the hook for? But by your own argument, you think it would have been fine if they would have just said that it would be totally unknown?
Well, not that. What I mean is the service agreement was simply silent. There was no indication whatsoever that we might have this responsibility in the service agreement. And the service agreement, remember, is functioning as sort of the tariff is the menu, and here's what I'm taking up. Here's what I'm paying for. So all I meant was if there was some sort of caveat, if there was some sort of notation that you may be responsible for X, Y, or Z creditable upgrade, it's not been determined yet what that ultimate price is. That would have been more than what happened.
But would that have been okay? I mean, would that have been enough? So you would have gotten a heads up that the precise amount, and even more than the precise amount, the precise way in which we're going to calculate the amount, that's unknown. If you would have gotten notice that it's unknown, would your notice-based challenges not exist? Or do you have something more to say than that?
In this case, well, no, our notice challenges go beyond that. I mean, for example, in this part of the brief, I think I'm trying to highlight what the difference between what our studies determined, indicated we were responsible for, what was in our service agreements, and what they didn't say. To comply with the tariff, it would need to specify the upgrade and the cost.
And if the tariff just said, like this suggests that the agreements would have said that it is unknown at this time whether the particular upgrade costs will be assignable to you, would that have been enough if the tariff said that?
No, I don't think so.
You don't think so? The tariff would have to say more.
Well, the service agreement, I'm sorry, maybe I misunderstood. You're saying tariff said you could be responsible for upgrades?
Right.
No, I don't think so. I mean, I was just discussing the rule, but-for rule. This is a rule that defines who is responsible. If the tariff simply said you might have to pay this, that would clearly be insufficient.
That would be insufficient, right?
Yeah.
That's your argument. That's why I was just thrown a little bit by the language in the brief, which made it seem like it would actually be sufficient if there were just a statement about it being unknown. But that doesn't seem to be your argument. That wouldn't be enough.
Right.
That's a statement.
Now, would you think that the regional operator was required to amend the tier to specifically include this reservation stack analysis?
I think that they should have amended the tariff to include it. I mean, interveners in FERC have characterized it as a business practice, which is, we don't agree that this is a business practice. It was not presented as such or comply with the normal rules for a business practice, but business practices are certainly allowable, and they may specify the finer details of how to implement tariff language. But it's pretty standard rule at FERC that business practices cannot vary the tariff. They can't contradict the tariff. And to the extent this is a rule that affects service as it does, it should have been on file with FERC, yes.
What about the fact that the petitioners here agreed to the methodology in the white paper?
So
it's not just a business practice, but it is a business practice that the petitioners explicitly approved.
Well, I guess, Your Honor, respectfully would disagree that it is a business practice. You're correct that petitioners endorsed the white paper back in 2012. However, for its part, my client did not understand the white paper to be proposing an alteration in the meaning of attachment Z2.
Well,
essentially,
if your client thought it was N-1, and then the white paper says reverse stack methodology, then it seems quite obvious. I mean, if that was their understanding originally, why would they endorse the white paper?
well, I don't think they understood at the time what the intent was. I mean, I think if you look, if we could just go to the white paper for a second.
Okay.
It does propose,
What
obviously.
page are you on?
Oh, I'm sorry. This is 275 of the Joint Appendix, page 3 of the white paper. So if we look on page 3, and my point would be, I don't think that the white paper is entirely crystal clear. And I'm not sure, my client did not understand that the intent of this was to change the tariff. And it was a white paper process. It was not it was a stakeholder process about the white paper and the issues of implementing it too, but it was not a process to change the tariff, which is a different and separate process under SPP.
But didn't everybody understand, everybody had to understand that the tariff was changed, at least insofar as it would now go in both directions. I thought that was the whole point of going from Z to Z1, Z2, or am I?
Oh, yeah,
thinking
no,
of something
you're
else?
correct. That's what happened in 2008. And when
Oh, I see.
filed in 2008, they changed
Got
that.
it, got it, okay.
But Judge Rao, just to my point, the last paragraph of page 3 is talking about applying an N-1 analysis to sponsored upgrades to determine whether it's needed for the service. Now, this passage is discussing application of N-1 tests to a subset of creditable upgrades, which are these so-called sponsored upgrades, and there are also.
But N-1, that's, again, like that's the initial allocation, right? Isn't a sponsored upgrade referring to an initial allocation?
I think this is talking about after sponsored upgrade. This is a sponsored upgrade that's been built, and it's trying to determine whether to apply, whether it moves from the status of sponsored upgrade to creditable.
That's why it's under Z2, because Z1 has to do with the sponsor upgrade, right? And Z2 is the credit mechanism by which this sponsor upgrade gets reimbursed through revenue credits. No, am I understanding that?
I think you're on the right track. Z2 is definitely talking about the credits. That's when Z1 is a little broader. It kind of talks about the process by which SPP does its studies. And it talks about the aggregate transmission service study, which is where SPP is batching a bunch of these together, and it does talk about sponsored upgrades.
I mean, here it says there's an N-1 analysis prior to the application of the RSA. It's talking about how that will be used to determine sponsored upgrades, but once a sponsored upgrade becomes a creditable upgrade, it will become the base values used in the RSA, the reservation stack analysis.
Mm-hmm.
So that seems pretty clear to me that the reservation stack analysis will be used for upgrade credits.
That's true. And I'm not trying to steer you away from that, but
I mean,
this
but
is
you
an
just said it was
ex post
unclear, but this
N-1.
actually, like, pointing me to this paragraph suggests it was quite clear that at least in the white paper, the reservation stack analysis would be used for upgrade credits.
Yeah, but this page 3 is talking about applying an N-1 ex post to an upgrade. Well, and Judge Rao, I think we had a little bit of this discussion during the Oklahoma gas case. You asked about the same question. And as I told you there that Xcel did not understand that it was approving a change to the tariff. And I understand any skepticism you may have, but ultimately, we have a contract with SPP that is comprised of the tariff and the service agreement. And if there was misunderstanding during the white paper process, that's unfortunate, but we've intended to stand on our contract rights, and the contract has not changed.
And I was going to ask you about that because it appears like the white paper is more going to a feasibility analysis. And then how do you feel like it affects the intent of the parties? Because it comes way later than the agreement.
Yeah, I don't think it's indicative of the intent of the parties in 2008 because it was developed in 2012. It highlights that the N-1 approach is one approach to determining whether transmission service needs to use a credible upgrade. It doesn't express any intent that this is always what they intended. It more is indicating that they did not know how to implement attachment Z2 at that time.
What is the ambiguity you're seeing in this paragraph again? Because I guess I'm following up on Judge Rao's question, it seems like the second sentence of that paragraph says the N-1 analysis will be used to determine whether the sponsored upgrade is needed to provide the new service, which is the antecedent stage where you're trying to decide whether the upgrade is going to happen, not what the methodology is for determining how the sponsor will be reimbursed by users of the upgrade.
Right, and maybe, so the reason I directed us to this page was just, number one, there's this suggestion, not by Judge Rao herself, but by FERC and the interveners, that the N-1 test can't be used after the fact. And this clearly shows that at least the white paper contemplates it. And number two, this white paper, frankly, I suppose I'm trying to show that my client could have been confused and not understand that they did not intend to apply an N-1 test throughout.
My colleagues have no additional questions for you this time. I guess we'll hear from counsel for the other petitioner.
Thank you.
Ms. Kimmel?
Yes, good morning. Can you hear me okay?
Yes.
Okay, thank you. May it please the court, my name is Phyllis Kimmel, and I'm arguing on behalf of Kansas Electric Power Cooperative and on behalf of petitioners. I will be addressing the filed rate doctrine and the study process rules. I'd like to reserve 2 minutes for rebuttal. At the outset, even if this court agrees that or finds that SPP was implementing the attachment C2 tariff correctly, there are still two fundamental problems with FERC's orders. One is the filed rate doctrine, and the other is SPP's violation of the study process rules.
So Ms. Kimmel, here the but-for method was, well, it's not about, say the but-for standard for upgrade credits was put into the filed tariff. And that standard was arguably underdetermined. Right? It didn't say how but-for would be calculated. So what I'm wondering is, in a situation like that where a tariff has clearly set out that some rate will be paid, right? That petitioners in this situation would pay upgrade credits, but the method for calculating that is left undetermined. Does that mean upgrade credits cannot be charged by SPP until there's a further filing? Because it seems that that might be the consequence of petitioner's position here. So where there's an underdetermined rate, nothing can really be charged until there's a further filing.
I mean, it could be that that could end up being a result. I mean, the Federal Power Act requires that charges be, that customers receive notice, formal notice of charges in a specific manner. And here in this case, the service agreement is where the customers receive notice of their actual charges. There were a couple of questions earlier. Would it, the statement in our brief about would it have been enough to say that the charges are unknown? The brief we were trying to make a point, and perhaps it was a little imprecise. If there's a tension, if the service agreements had said we have no idea what upgrades you're going to be charged for, and we have no idea what those charges will be, customers would have at least had actual notice as to what was going on. Would that have been compliant with the Federal Power Act Section 205 requirements for charging rates? I don't believe that it would.
Well, but the petitioners here don't question that they were on the hook for upgrade credits. I mean, that was part of the tariff, that some upgrade credits would be paid. Maybe they didn't know how those would be calculated.
Well, petitioners,
But petitioners knew that they would have to pay for upgrade credits in some way.
in some way, sure, but where in the study process, there were SPP was obligated to provide notice in the study process of the upgrades and of the cost of the upgrades. In KEPCO's case, over half of the costs that my client is being charged are for upgrades that, as far as we can tell from the study, weren't even at issue at that point. And so, you know, we do believe that's a problem, both with compliance with the study process rules and compliance with the filed rate doctrine.
So Ms. Kimmel, if the white paper had been filed with FERC, or, you know, some version of that explaining this methodology, would that have been sufficient to satisfy the filed rate doctrine?
If the white paper had been filed and the tariffs specified how the charges were to be calculated, and if the service agreements had specified the charges, those two components absolutely would have been sufficient. But what we have here is not the case of a formula rate where you can just flow inputs in after the fact. That's just not what is on.
Oh, wait, I didn't quite, can I just have a second?
Sure.
Because I thought that you added a few things to just the white paper.
Mhm.
So what if just the white paper were baked into the tariff? The tariff cross-references the white paper and says, look at the white paper. And that's it.
If the white paper had been filed, then we'd have a harder case to make here, Your Honor, but that's not what.
But would it have been enough?
Would that have been enough?
Yeah.
No, I don't think that it is. I think that we have not found anything in all of FERC's precedent, in the court's precedent, saying that a service agreement need not specify the actual charges. We just haven't found that. And as far as we know, that is pretty clearly what the Federal Power Act Section 205 requires. That's what FERC's rate regulations require. We're just not aware of anything where a service agreement can omit the actual charges, with the exception
what does the service agreement have to do with the filed rate doctrine? Because I thought, and maybe it's a separate argument, but I thought part of your argument was that the filed rate didn't give you enough notice, not the ultimate agreement.
So our position is that the service agreement is the filed rate. That's where the charges to the customer appear.
Oh, because I see. Okay.
Mm-hmm. Yes, I mean there's as Mr. Lowell explained, there is SPP has a tariff. It's got thousands of pages, all kinds of terms and conditions. Different charges need to be calculated in compliance and consistent with that tariff. But in the end, there's a service agreement, and it says KEPCO is going to pay $100 or KEPCO is going to pay $10 million. And if we don't have that information when we're presented with that service agreement, there's just no way for us to make an informed decision about whether we want to take on the costs that.
And the agreement gets filed.
That gets complicated. The agreement, the service agreements used to get filed, and then FERC's regulations changed. And under certain circumstances, they are filed, but the rules treat them for the same purpose as if they were filed. It's in 35.1G, I believe, of FERC's regulations, but it has the same effect.
Can I go back to one question that Judge Rao started with, which is that you agree that you knew that you would have to pay something by way of credits under Z2?
Yes, I mean there is always the possibility of having to pay credits, both.
No, not the possibility, not the possibility. I'm trying to figure out whether you knew that you were on the hook as a but-for causer.
In this case, when the service agreement said that there is only one upgrade, or that there was only one upgrade that was status, whatever, that met the but-for test. And in that case, the costs are not directly assignable to KEPCO. No, we didn't expect that we'd be paying for that. And there were 4 upgrades that just were being charged for that weren't even part of the study process. They came along later. And no, for that totaled over half of the $6 million. And no, we did not have notice of that.
Because what I'm trying to understand is, what I'm trying to understand is the following, is that on your argument that the use of, I guess it's the RSA test, the RSA analysis, that the RS analysis, sorry, I didn't mean to repeat the A, that it doesn't satisfy the but-for test. And I'm looking at paragraph 39 on JA 185, which I think is the commission's response to your rehearing petition. And it contains the following sentence: because there was insufficient available capacity in the forward direction immediately prior to the creditable upgrade, any use of the upgrade in that direction by a new reservation is considered to be facilitated by the additional capacity created by the upgrade, and thus satisfy the but-for test. So I take it the commission's view, and we can ask the commission about it, is once you know that a new request results in the use of the upgrade in the forward direction, the same direction that gave rise to the need for the upgrade, well then but-for is already satisfied, because the only way that would have been possible is the upgrade. And do you agree with that? Or do you think that's not true?
I'm not sure, but what I do know is that what's very clear is I'll start with the low-hanging fruit. The upgrades that weren't studied, that Kansas Electric put in a request for service, and there were 4 upgrades identified as potentially being needed to be made so that we could have the service. Now there's new upgrades that we're being charged for. So there's no but for, as a factual matter, there's just no but for, or, on those.
What's wrong with that sentence, I guess, is my question. You must think there's something wrong with that sentence, because as I understand it, that's the commission's explanation for how its implementation of Z2 in the forward direction satisfies the but-for test. You obviously think that the way they do it does not satisfy the but-for test.
Maybe I'm missing something. What I'm saying?
They think any use of the upgrade in the forward direction necessarily satisfies the but-for test. Well, we can ask the commission this, but that's my understanding of the rationale.
Yes, I mean, right.
And you must disagree with that. You must think that's not true. Not any use in the forward direction by a new reservation.
We have 2 problems with it. One is the sentence itself, but 2 is that there's a premise that there are upgrades that you're looking at measuring whether there's a use in either direction. And our point is that at the time when the service requests were put in, these upgrades weren't even identified as being needed in the first instance. So we don't understand how we can then legally be or lawfully be charged for those.
I see. Okay.
Ms. Kimmel, can I ask you a question about the standard of review here? I mean, this is a Section 206 proceeding. So petitioners bear the burden to show that the rate is unjust and unreasonable. Do you agree
Well,
that that's the standard here and that?
No, Your Honor, it is a 206 filing, but what we have argued is there's a couple of different ways that a section 206 complaint can be made. One is that you're arguing that the existing tariff is unjust and unreasonable, and then you advocate for a replacement. What we're saying here, and a different type of filing made under 206 and actually 306, 309 of the Federal Power Act, is that there is a rate on file, which we believe was our service agreement, and that wasn't complied with. So there is our view is that there is a violation of the filed rate doctrine, and so it's a different standard.
And do we, counsel for the other petitioner suggested we review FERC's determination here under the arbitrary and capricious standard. Do you agree with that? Or do you believe that we review it de novo?
The contract.
So FERC has said here that there's no violation of the filed rate doctrine. Do we review that determination for reasonableness, or do we review it de novo? I believe Mr. Lowell said that we review it for reasonableness under the arbitrary and capricious standard.
I would need to double check that, Your Honor. The de novo, to my knowledge, the de novo review comes into the contract interpretation, whether the court believes that the language of attachment Z2 itself is ambiguous. But I would need to double check that, and I can find the answer and perhaps answer on rebuttal.
Okay, let me make sure my colleagues don't have additional questions for you. All right, we'll give you a little time for rebuttal.
Thank
We'll
you.
hear from the commission now. Ms. Pasella.
Good morning, Your Honor. Beth Pasella for the commission. Can you hear me?
Yes.
Okay, thank you. I think I'll start with, I guess that last question that Judge Rao just asked, and certainly the interpretation of the statute itself is not really an issue here. The commission used its own expertise to explain why the filed rate doctrine is satisfied. It interpreted a tariff here, and the commission approves that tariff. The commission has reviewed that tariff over the years. So it is definitely arbitrary and capricious review regarding the commission's determination.
But the filed rate doctrine is rooted in statutory requirements. So whether there's been a violation of the law, which is, sort of encapsulated in the filed rate doctrine, why wouldn't we review that de novo?
Because we're not interpreting the statute, and I'm not saying that would be not arbitrary and capricious review if we were, but we don't even have that situation here. What we have here is the commission interpreting a tariff that it reviews and its own precedent to determine whether the filed rate doctrine, as this court has set it out in Oklahoma Gas and other cases, is satisfied. And that is quintessential agency arbitrary and capricious review matter.
So I have a question about this. To comply with the filed rate doctrine, the tariff here, Z2 is at least, even if it's not quite ambiguous, it's underdetermined. It doesn't say how but-for is going to be calculated.
It doesn't specifically say that.
It doesn't specifically.
It does indicate, we believe, Your Honor, the commission believes, does indicate that it will be using a subsequent use analysis.
Mm-hmm. Okay, but so why, in a situation like this, where you have a term like but-for and the methodology, there's no clear formula set out, like no precise formula set out in the tariff. When the parties, when SPP and its stakeholders agree to the white paper, why wouldn't the white paper be filed with FERC? Would something like that ordinarily be filed with FERC?
So, I will answer your question. I just want to say, petitioners have never argued that the white paper should have been filed with FERC. So I don't really think that.
Well, that might fix the filed rate doctrine concern, though, right? If the RSA methodology had been filed explicitly with FERC, amending the tariff or updating the tariff or
yes. And
whatever.
so to answer your question now,
Mm-hmm.
of course I need to, and I want to.
Mm-hmm.
That happens. There are white papers and business practice manuals all the time that are not filed with FERC. That is the normal, ordinary course of business. And that's because tariffs themselves are extremely long, and you cannot include in a tariff every detail that is then explained further in a business practice manual or a white paper. There is a standard to determine that the commission uses called the rule of reason, which is again not raised in this brief. Petitioners are not arguing that the rule of reason it wasn't raised to the commission. No one has argued this, but the point is you determine using the rule of reason, and I don't know the specifics of it because it's not before the court here, and so I didn't learn enough about it. But basically the idea is using this rule of reason analysis, the commission determines whether there's enough in something that it has to be included in the tariff or not. And that's not been questioned here.
Is that rule of reason standard from the Keyspan Ravenswood case, the Judge Scalia case?
I
in the 80s?
apologize for, I just learned, and because had not been raised, I didn't learn more about that, and I apologize for that, and it may well be. But it is an established commission method for determining whether something needs to be in the tariff.
Because in that case from the 80s, which has been cited even recently by this court, then Judge Scalia says, well, things that can be specified should be specified in a filed rate. And so obviously, when they do the white paper and they come up with this methodology, I mean, in some ways that's showing that it's capable of specification. So why does that not then have to be filed with FERC?
I apologize. I just don't know what the commission's view. I can tell you what Castella's view on that is because of the very reason that I'm explaining is that tariffs are very long. And that is just fact. Tariffs are very, very long, and everything is just not included in. That is normal, typical business practice. It's just how things are done.
So what you're suggesting is we should consider this case as if the white paper were in the filed rate.
No, I'm not arguing that the commission did not rely on the white paper as being part of the filed rate here because it's not filed with the commission. The commission only considered the white paper for purposes of determining as a last piece of information, determining whether what the ambiguous meaning of the specific meaning of but-for means under the tariff.
So with respect to their argument that says they didn't have enough notice of what they'd be on the hook for, from the commission's perspective, what documents should we be taking into account to determine whether they had enough notice?
So the commission found that there was adequate formal notice from four things. One is the text itself, of course. The text provided.
That's just saying that there's going to be a but-for standard.
It's explaining not just that, Your Honor, that there's going to be a but-for standard, but in the introductory paragraph of attachment Z2, section 2 at 827, and in attachment Z2, section 2B at 828 of the petitioner's brief, the opening brief, where the provisions are set out. The introductory paragraph and those other provisions, which I'll be happy to go through. I've set them out in my brief, but I'm happy to do it here as well. They point out not only will there be a but-for causation test, but that it will be conducted based on a subsequent use analysis. And that is what the reservation stack analysis ends up recommending. And so it's not a change to the tariff. The commission's point is that's exactly what the tariff said it would do. The original.
But didn't you only argue three sources for, with respect to issue 2?
I'm sorry, Your Honor?
Did you only argue or support 3 sources for issue 2? You're saying 4 now?
No, I'm sorry. So there's the tariff. There's the explanation in SPP's filings and the commission's orders regarding those filings. And I may have misspoken. And the service agreements. So I broke down the explanation.
But those don't go into that much more depth than what's already in the tariff. Do they? Is something material added by the other things you just ticked off?
I'm sorry, Your Honor?
I'm trying to figure out what do we look at to determine whether there was enough notice. So the things that you just told us we look at are this, 827 and 828, which is the tariff.
Right.
And then you ticked off a couple of other things, the service agreements, and then one other item.
And the
SPP's
tariff filings.
Right. And what I'm wondering is, for things beyond the tariff, things beyond what's A27 and A28, what do those other things add to what's already in A27 and A28?
So what those things add, well, first let me say that the tariff, again, it indicates that a subsequent use analysis will be used. And then the filings that were made regarding attachment Z, which pre-existed attachment Z2, they explained that a subsequent use analysis was used there. And then in the 2008 filing that
So that doesn't sound like that adds much.
Well, what it does is, this is my next point. One of the things SPP explained in its 2008 tariff filing, along with it in its transmittal letter explaining its filing, was that and this is at, it's in the Kansas Electric Order, paragraph 69, JA 122, and it's citing the transmittal letter, which is at JA 420. And it explained that the proposal is consistent with then existing tariff attachment Z's requirement that customers pay for new or increased uses of network upgrades. So the tariff filing itself explained that it was going to continue to use the subsequent use analysis as part of this. It's now added this but-for language, but it explained why it changed the language. And it explained in that filing that it changed the language to recognize that there could be benefits in the opposite direction, not only in the forward direction. So there were free riders before, and now there wouldn't be free riders.
So are you saying that this attachment to Z2 is ambiguous?
Attachment Z2 is ambiguous, but only as to the specific but-for analysis that will be used. It's not ambiguous that there will be a but-for causation analysis. You just don't know which kind. And it indicates, the text itself indicates there'll be subsequent use. SPP's tariff filings indicate there'll be subsequent use. The commission's orders indicate that it's always understood that there will be a subsequent use analysis for this, before when it was attachment Z and now that it's attachment Z2.
But how does the but-for and then the subsequent use analysis interplay with each other?
Right. Good question, and I'm happy to explain that. As the commission explained, need is satisfied under Rule 1, as Your Honor was explained. Since SPP has already determined under attachment Z1's N-1 contingency analysis that the upgrade was needed to relieve flow constraint caused by the upgrade sponsor's service request, all new reservations that flow in that same direction are considered to also be, they also need that upgrade capacity. So you know that before the upgrade service couldn't be provided. That prompted the upgrade in the first place. So anything flowing in that same direction also would need that capacity.
Why?
That the upgrade provides.
I guess I don't understand that, because isn't it possible if where the electricity goes is based on kind of a second-by-second estimation of where's the best place for it to go, which is the way it's been laid out to us. And how do we know that just because in one instant it's determined that it will use the new path means that it could only get through if it used the new path, that it wouldn't have also gotten through anyway, regardless of the new path?
So
how do we know that?
The analysis that's set out in the tariff is not the same type of need level that you would need, right? So there is a simplifying assumption here that if you have a certain amount of capacity on the system, you need an upgrade to provide the upgrade sponsor service, anything that's going to flow on that. I understand that that's system, but that's based on the tariff. The tariff says we will do it based on subsequent use.
No, but I guess what I don't follow with that is, of course, it's based on subsequent use, and I see the word subsequent use in the tariff and in the subsequent filings from SPP and maybe in the service agreement too. You can point me to that. There's references to subsequent use, but just because there's a reference to subsequent use, I don't think it necessarily means, but you can tell me why this is wrong, that every subsequent use satisfies the but-for test. It just says that in determining whether the but-for test is satisfied, we'll base it on subsequent uses. And it seems to me, yeah, that makes perfect sense. You'd base it on subsequent uses. You don't know yet what use is coming down. So you look at the subsequent uses and you determine whether they satisfy the but-for test. But it doesn't necessarily mean, I don't think, but you can tell me why this is wrong, that every subsequent use, just using the term subsequent use in a tariff was supposed to put somebody on notice that every subsequent use of the new pathway satisfies the but-for test.
If you're going in the same direction.
If you're going in the same direction, yeah, exactly.
Right. Only if you're going in the same.
Yes, yeah, only the same.
And that's because remember attachment Z only had a subsequent use test. It didn't have, and going in one direction. If you flowed in the same direction, then you were on the hook for upgrade costs as reimbursement. And when
You're talking Z, meaning before there was a divide to Z1
right.
and Z2?
And so when SPP changed the tariff to the Z2 language, it wasn't changing. It didn't take out any of the subsequent use language. It took out the directional language. It added in the could not be provided but for language. But it explained that the purpose of that was not to require that there's no way you could possibly be. It was just to bring in these former free riders who are going in the opposite direction. It didn't really mean but for in the same context that you might possibly think but for would mean. And that you were supposed to be using a subsequent, they again explained, continue to use a subsequent use analysis. This is consistent with the prior provision. And so subsequent use is, are you flowing on the system? The commission didn't just stop there. Flows are not enough. The commission explained we are using subsequent use analysis. If we've already determined that we've already determined that under an N-1 contingency analysis that service could not be provided for the upgrade sponsor, then we are deeming this also to be needed. And it is a different standard. I'm not hiding from that. I'm not afraid of that. It's just, it's supposed to be a different standard. It's not supposed to be like an N-1.
So you use the word, and I appreciate the use of the words deeming it to be, because it does sound to me then that it's kind of like a proxy. It's just saying, we're just going to assume that every subsequent use wouldn't have been possible but for the upgrade.
Because we already have had this N-1 contingency.
Yes. So in other words, there are definitely some uses in the future that wouldn't be possible but for the upgrade, because that's established by the Z1 N1 complex, because the only reason you have the upgrade is because there's a capacity constraint, and there needs to be an expansion of the capacity in order to accommodate some new requests. But if whether a particular new request would have been possible but for the upgrade, it sounds to me like what you're saying is it was always understood, including at the time before the Z1, Z2 divide, when all we had was attachment Z, it was always understood that we never looked at whether a particular new use would have only been possible because of the upgrade. We just assumed and we deemed that any new use was possible because of the upgrade. Even if it's possible, even if you could envision a universe.
Theoretically, it might not have been N-1 contingency but for needed. It possibly could have flowed somewhere else. But that's the point is, you're trying to figure out how to reimburse entities that build these upgrades. The tariff says subsequent use multiple times in this provision. The SPP's filings explain and the commission's orders explain that that was always intended to be continued to be used. So this is the commission's way of honoring both the but-for language and the subsequent use.
Okay, then I think I understand. I'm sorry to monopolize the question just for a second. I think I understand the commission's approach for why the way you're doing the RSA and RSA methodology satisfies the but-for test. And then in terms of notice, would you take the position that what's at 827 and 828, which includes a reference to subsequent incremental use, that was enough notice, that at that point the petitioners knew, because as long as they had a subsequent use on the new pathway, that they would be on the hook for something, that was enough. No more needed to be said about amounts, about precise way that the amount was going to be calculated.
It is certainly enough to put the petitioners on notice that they might have to pay if but-for causation is satisfied under attachment Z2, that they would be charged for credit payment.
Right, but if just telling somebody that you might be charged, is that enough to satisfy
It is because it's a rate rule, and I appreciate you bringing that up so I can explain this. As petitioners acknowledge in their reply brief at 22, under this court's precedent, and they cite Transwestern, the Transwestern case, a rate rule in a tariff can provide the necessary notice, and Z2 is a rate rule. So it is not a formula, but it is a rate rule that if but-for causation is satisfied under a subsequent use analysis, then you will be charged for credit payment obligations.
And
the specifics of that can be determined through a white paper or business practice manual.
But a rate rule means all you have to do is say that there's going to be a but-for analysis and it's going to be based on subsequent use. That's enough.
Sufficient, Your Honor. And I think the language of
Do we have a decision that says, what's the decision that says that a rate at that level of generality would be enough?
Petitioners, they can, as far as they conceded the point, they acknowledged this point, so I didn't further research that, but they cited Transwestern at 897 F. 2nd 57.
But we also have a lot of cases saying that the filed rate doctrine is kind of an impenetrable shield, and the only exceptions are very narrow, including whether there's a specific formula. And the filed rate cases that look at formulas, the formulas are very particular. They're not just something like some words like but for subsequent use. They're in fact formulas that different market conditions are then input into to find the actual amount that would be owed. So I'm not sure how this would fit under the exception to the filed rate doctrine for formulas.
So it's an odd position for me to tell you what the court's precedent means, and I apologize, but let me tell you our view of what the court's precedent says. As the court said in Oklahoma Gas, quote, notice may satisfy the filed rate doctrine when entities have formal notice of the rates, either through a FERC proceeding or through the courts. And it talks about the two examples of situations in which continually the court.
I wrote Oklahoma Gas.
Exactly. So, but the point is and in Old Dominion, the court said that there's no violation of the filed rate doctrine when buyers are on adequate notice that resolution of some specific issue may cause a later adjustment to the rate being collected at the time of service. So these things together, all of the things the commission are relying on are things that were filed with the commission. The commission did not rely on anything that was not filed in a FERC proceeding, and also the tariff, obviously, but even the SPP rate filings, that explanations are contemporaneous with the filing itself to explain.
I think this case is different from some of our other filed rate cases because it really is about the degree of specification that is necessary. I think the petitioners concede that they owe some kind of upgrade based on the tariff. And then the question is, how specific does that have to be? Which is why I was asking you about that Keyspan Ravenswood case, which is like one of the early cases discussing that. And then I think if it really is about how specific it has to be, then the standard of review does become quite important, right? If we're reviewing this for whether FERC is being reasonable in terms of how they interpret the degree of specification, or whether we have to make a kind of de novo legal determination whether this level of specification is sufficient to meet the filed rate doctrine. And I think that, I feel like I'm not sure I've gotten a very clear answer about that, or with citations to our cases about how this question of specification should be reviewed by this court.
I think petitioner's point wasn't that the tariff wasn't specific enough, Your Honor. I think the petitioner's point was that the service agreements needed to list the upgrades.
So you think that issue just isn't preserved?
I don't think that's preserved. I really don't. I spent a lot of time preparing for this case. I would have spent a lot of time on the rule of reason and all of that case law.
But isn't it sort of basically that question when they say it doesn't satisfy the filed rate doctrine? They're saying there's no filed rate, right? It's not specific enough. Like, we don't know what we owed because the formula wasn't filed with FERC. So we were not on notice. There's nothing in Z2 that tells us how, we would know what we owed.
But they're not saying something wasn't filed with FERC. That's what I'm saying. They're saying what the commission relied on wasn't sufficient. And that's a very different argument. And the commission didn't rely on anything that wasn't filed with FERC for purposes of determining the file.
But I thought what they're saying is the stuff that was filed with FERC didn't give us enough notice about what we would owe.
Right, and that's based on their argument that it needed to be in the service agreement, which just isn't true. I mean, there's no, they're only pointing to the filed rate doctrine to say that. And the service agreements explicitly incorporated the tariff and the service agreements.
But I don't think they dispute that it incorporated the tariff. I think what they're saying is, taking into account the tariff, that's 827, 828, I think, right? They're just saying those words just don't give us enough notice of what we might owe. And the whole point of the filed rate doctrine is that it's supposed to make us make an intelligent choice based on what we might be on the hook for. So it has to be at some level of specificity. I mean, the best would be something that tells us exactly what we owe. And then I think we can all agree that it doesn't require that. But it has to give you some indication of what you might owe.
I think, and perhaps I'm wrong, but I really think that their argument is a little different than that. Their argument really is the tariff said what the tariff said, but the service agreements needed to specifically set out what upgrades we would be charged with. And
But aren't you also relying a lot on the white paper that's, not filed, but something that's in play years later?
Not for purposes of the filed rate doctrine matter, Your Honor. The Commission is only relying on the white paper for purposes of determining what the ambiguous but for provision.
Can I just, I'm sorry to interrupt, but I want to make sure we still have the connection. Okay, sorry, I just want to make sure the council,
Okay.
we lost our screen. Sorry,
Okay.
please.
No, she can finish.
Oh, okay.
Thanks.
Can I just ask a factual question? Has FERC ever used the N-1 analysis for something other than initial allocation of
Absolutely not.
credits? Okay.
Petitioner doesn't cite any case in which we have, and we are completely unaware of any situation. It is only an initial cost allocation.
So from FERC's understanding, is the petitioner's argument that this is unreasonable because, is the main reason that this is unreasonable from petitioners, like what petitioners advanced to FERC, that SPP failed to use the N-1 analysis?
Certainly that was Xcel's argument below, and it's definitely wends its way through the petitioner's briefs. They say in their reply brief that they're not saying that. Kansas Electric didn't argue the same way that it has to be an N-1 contingency analysis to the commission. I don't know what other analysis they think should be, used. I mean, the stakeholder process, thought about this pretty hard, and the white paper set all this out. And my understanding is, and perhaps I'm wrong, that the record indicates that Xcel was actually on the credit task force.
So because this is a 206 proceeding, the petitioners have the burden
That's right.
to show that it's unlawful or unjust and unreasonable. Either one.
I'm sorry?
It can be under 206, one of their arguments could be that it's unlawful, right? Because it violates the filed rate doctrine.
Whatever the standard is, it's petitioner's burden. That's right.
What is the standard?
Standard, in our view, it's arbitrary and capricious review, except for the determination whether Z2 is plain or ambiguous.
But to the extent that under 206, the petitioners are arguing that there's been a violation of the filed rate doctrine, isn't that a legal argument under 206?
It is.
And if it's a legal argument, right, that there's been a violation of the filed rate doctrine, isn't that something we review de novo?
I think it's for the court to determine. They don't argue.
So
Petitioners didn't
what
argue
is
to the
context?
commission that the filed rate doctrine requires something different than what the commission addressed. Petitioner's argument is that the commission improperly analyzed the tariff and the service agreement requirements, which are all FERC approved, FERC regulated, FERC jurisdictional things. And this is very plainly, I mean, this is a complicated case, and your honors are, please don't take this as that I'm insulting your intelligence, because I'm certainly not, but this is really quintessential FERC stuff. This is hard to understand and it takes the commission's expertise to figure this out. This isn't just some issue that perhaps would be anybody, an Article 3 judge without the expertise that FERC has could decide on its own, respectfully.
I think it's interesting that in my response to what the standard of review is, you fall back on, well, FERC is the expert agency, right? Because if there is a legal question that is at the heart of this, then we have to review that de novo. And I just feel like you're not quite answering that question. Well, and I think to fall back just on the commission's expertise, which I respect, is not an answer to the standard of review question.
So perhaps I'm not understanding exactly what your question is. I'm not trying not to answer it, but I guess it's because the issues petition, it's not something that petitioners have argued, that they're not saying the commission misinterpreted the statute, the statutory requirements. They're saying
of the filed rate doctrine.
Of the filed rate doctrine. They're saying, and they're not saying that the commission misunderstood what the commission viewed as Oklahoma Gas saying that matters filed with the commission are part of the filed rate doctrine. They can provide notice with the filed rate doctrine. They're not disputing any of that. Their dispute simply is that the commission's analysis of its view, its expert view, satisfies the filed rate doctrine requirements as set out, and it's accepting what the court has said. It's not interpreting the statute. It's just interpreting the tariff to see whether it provided adequate notice and whether the service agreement provided adequate notice and whether so I just don't see.
So you don't understand the petitioners to be saying that this tariff, that Z2 violates the filed rate doctrine because it was not specific as to what upgrade credits? You do not understand them to be saying that. I guess we'll ask them on rebuttal.
I do not see it that way, and the commission did not see it that way. The commission and I viewed it as simply being that the service agreements needed to list and that's a 2013. That's a different tariff later on that was required in 2018 that you had included in service agreements. That's what the basis of their argument was. We didn't know because you didn't list them in the service agreement. And they also make their Z1 argument.
So as far as you're concerned, FERC hasn't even made an argument in its briefings that they got enough notice about the level of costs that they might be subject to, because you didn't understand them to be arguing that you hadn't been specific enough.
Oh no, the commission absolutely believes that they were adequately notified from the tariff and the service agreement and the commission's orders in the prior orders and SPP's filings that they would be charged for these if the subsequent use but-for analysis was satisfied.
No, not the fact of whether they would be on the hook, whether they knew enough about how much.
But that's the commission's point is that that's sufficient, Your Honor. There was no requirement anywhere.
So the commission thinks that as long as the filed rate tells somebody you're going to be on the hook for something, we won't tell you what, you're just going to be on the hook for something. And then later on, we'll tell you what. That's enough notice.
Well, because it's a rate rule. So it's just kind of like with a formula rate, and they're different, and I understand that. But there's a rate rule that you will be charged to reimburse entities who pay for upgrades. You will be charged to reimburse them based on subsequent use analysis that if the subsequent use but-for causation is satisfied. And that's all that needed to be in the tariff.
I have a couple of other just follow-ups. So that's right. On Z1 and Z2, one thing I'm not quite understanding, and I'll ask the Intervenors Council this too, is I had understood that Z1 tells the upgrade sponsor it's speaking to the upgrade sponsor.
That's right. Your
Not to upgrade users.
That's
It's
right.
talking to upgrade sponsors, and it's talking about the fact that if you're the upgrade sponsor, then you're initially on the hook for the cost of the upgrade. And then Z2 then goes on to say that the upgrade sponsor can be reimbursed from upgrade users through the revenue credits.
That's right, Your Honor. So there really wasn't any obligation under that the study provide creditable upgrade notification.
But then why didn't the commission, I don't see anything, and even in your brief or in the commission's, and if I could just finish the question, because I know you're antsy, but I just want to just get out my question to make sure that you're addressing the question that I
Appreciate
have. Why wouldn't the most straightforward answer have been, why are you even making a claim under Z1? Because you're a Z2 entity, you're an upgrade user, you're not a Z1 entity. So we didn't owe you any notice under Z1. Z1 wasn't speaking to you. Z2 speaks to you. Do you understand my question?
I absolutely do.
And I didn't see that answer anywhere.
So it is, as the intervener brief pointed out, it is in the orders a bit. The commission says it at
Is it in the brief? Can I just ask you? And I'm not trying to pick, I'm not trying to say
No, I hear you. Well, here's why it doesn't have to be in the brief. While I'm finding that, I'm looking at the wrong page. I apologize. That is something that the court can decide on its own, because that.
But I guess the thing is, well, the brief, from what I read in your brief, and I thought in the orders too, it's assuming that Z1.
Exactly.
It is assuming that Z1 is relevant.
Right.
And it's saying, and we did provide enough notice under Z1, where it seems like the better, or at least the more fundamental answer is, why are we even talking about Z1 with you?
Exactly, Your Honor. And that's what happened during my preparation for the briefing. And as intervener's brief points out, and FERC brief at 8 does point this out as well, that in the Kansas Electric Rehearing Order at JA 168 to 69, paragraphs 4 and 5 and note 9, and at JA 177, paragraph 23, which quotes the C1 provision, and in the Xcel Rehearing Order JA 443, paragraphs 4 and 5, the commission explains that Z1 is about identifying and providing estimates for new upgrades. And these are not new upgrades under Z2. You're dealing with existing upgrades. So that's all the commission said about that in the orders, but your honors can decide this issue on your own, because it has, your honor figured out, Z1 just plainly doesn't apply to these creditable upgrades.
Then the question is whether we think that the orders actually rely on that rationale, because we can't supply a rationale that's not in the orders.
Well,
themselves.
you can actually when something is plain, and I apologize for not having the precedent for that, but and that's been written in an opinion where the court said it wasn't in the commission's order, but fortunately that doesn't matter, because we are making a determination based on the provision itself that it's plain, but you would do de novo yourselves anyway, and you can make that determination even if it's not in the commission's order. And
I want to make sure.
Just Z1 and does Z1 incorporate Z2 charges, or is that different?
Z1 does not incorporate Z2 charges. They have different but-for analyses. Z1 is, as the commission explained, that it's about new upgrades, determining whether someone comes in and asks for something, what's limiting your service. Z2 is about what you used. You weren't limited by those upgrades. The upgrades existed and you were able to use them, and therefore you pay under Z2.
My last question, I think, is not about Z1, Z2. It's about Rule 1, Rule 2, which goes to the implementation of Z2. And it's more a conceptual question. And that it's the way Rule 1 is laid out, it makes the assumption, the deeming that we talked about earlier, which is that every use by a new requester satisfies the but-for test. And therefore, we don't have to go through and try to figure out which particular uses are only made possible by the upgrade. That's the way Rule 1 is spelled out, because it's going in the forward direction. And then when you come in the backward direction, the reverse direction, whatever the terminology is, we need to do more than that. We can't just assume that a use in the reverse direction satisfies the but-for test. We have to drill down deeper, and we have to figure out whether this particular use is one that is only brought about because of the
That's right.
change. And I guess my question is, if that can be done in the reverse direction, why isn't that just same thing being done in the forward direction?
All you're doing in the reverse direction is, not all, because it's plenty, but what the commission does, what the analysis requires in the reverse direction is that you look at the capacity before the upgrade and you determine whether the service request could be satisfied by that capacity before the upgrade. If it can be, the but-for causation test is not satisfied. If it can't be, the but-for causation test is satisfied. So an N-1 contingency analysis is completely different. You put the service request in, you take the upgrade out, and the commission explained the white paper explained, and the commission explained as well the three reasons why you just can't really do that. For
in other words, I get okay. So keep N-1 out of it because I'm not worried about the details of that. I guess conceptually what you're saying is, in the reverse direction, there was excess capacity. I mean, there was excess room, and so we can test whether the amount that's being used would have fit within that margin. In the forward direction, we already know there wasn't any excess room, so we're necessarily not.
Yeah, we just hadn't. The commission hadn't done. SPP hadn't done the analysis in the opposite direction under Z1.
Okay.
And so it needed to happen under something happened to happen under Z2, and that is the subsequent use analysis.
Be sure there's no further questions, and then thank you.
Thank you, Your Honor.
We'll hear from Interveners Council. Although before we do that, can I make sure that we lost the entire video feed? Do we still have counsel? We do. Okay. Mr. Bennett.
Good morning, Your Honors. May it please the court. Matt Bennett for SPP and the interveners. I'd like to start with what you were just discussing, which is the Rule 1. And I think you hit the nail on the head. Prior to the creditable upgrade, there was no ability to flow in that direction. So when that creditable upgrade was put into service, that alleviated that constraint. So when the next user comes into the system and wants to flow across that same constraint, that constraint's already been relieved because of the creditable upgrade. Whereas in the reverse direction, there's no guarantee that's the case, which is why SPP applies the extra tests under Rule 2. Now I'd like to turn to the filed rate doctrine issues that were discussed with Judge Rao's questions. I don't read the petitioner's briefs as saying that attachment Z2 was not detailed enough. In fact, they said attachment Z2 was unambiguous. They didn't say that attachment Z2 needed more detail. They said we applied the wrong test. Obviously, FERC found that it was ambiguous and found that multiple potential tests could satisfy the but-for and subsequent use language, and the one that we applied was reasonable. So their filed rate doctrine objection with respect to notice, I think, really arises under which upgrades they were going to be required to pay for, which is an attachment Z1 filed rate doctrine objection, which, as Ms. Pacella said, the tariff didn't require us to list the attachment Z2 upgrades in an attachment Z1 study agreement or study report or agreement, because those are two entirely separate processes. It wasn't until 2017 that SPP made a filing to modify its tariff to require SPP to now list creditable upgrades going forward in the network service agreements. And that's just simply to provide people with more information now that we have more information to provide.
Mr. Burnett, why didn't SPP file the white paper or, something like that? Say we're going to use this RSA, or RS analysis to calculate creditable upgrades. I guess is that the sort of thing that ordinarily would be filed with FERC because it specifies the rate or it affects the rate that will be paid?
It affects a rate, but as this court has found, there's an infinitude of practices that affect rates. That's the City of Cleveland case. I don't have the citation right in front of me. I apologize for that. Utilities rely all the time on unfiled manuals to supplement and provide the implementation details for the obligations that are set forth in the tariff. SPP's tariff already spans more than 5,000 pages. If SPP had to file every implementation detail, such as the white paper, its integrated marketplace protocols that provide the details for how SPP runs its day-ahead and real-time markets, the tariff would be 30,000 pages. So
Are you aware of other 206 cases that are 206 challenges that challenge the specification of a tariff and an implementation doctrine in this way?
I'm sorry, I don't quite understand the question.
Well, so the challenge here is that the specification, the white paper that, that set out essentially what they would pay was not filed. It wasn't part of the filed rate. And so therefore the filed rate is underspecified.
Well, the filed rate, as Ms. Casella said, there's the rate rule precedent, which is the tariff sets forth the obligation. And what the unfiled manuals do is they provide the detail as to how you calculate that obligation. So the tariff already says you will pay credits if your service could not be provided but for the upgrades. And obviously we have a difference in interpretation as to what but for means.
Right, but nobody questions that they owe upgrade credit.
Right. Yeah, it provides
calculated some way.
Right. But I mean, there are other provisions of the tariff that don't, and service agreements that don't provide specific charges. I mean, for example, SPP runs a 5-minute real-time balancing market across its 14-state footprint. SPP doesn't publish every one of those market prices in the tariff or in the protocols. They simply can't. So when you're talking about all these creditable upgrades, having to publish specifically what the charges are in either the tariff or the service agreements, is just, it becomes such a huge endeavor, and it's not really required if the obligations are already set forth in the tariff. And if the service agreement complies with the tariff attachment under which it was signed, which is attachment Z1. And they haven't suggested that we didn't comply with attachment Z1 with respect to identifying new upgrades that were required by their service. What their complaint is that we didn't identify the Z2 upgrades, but the Z2 and Z1 analyses are different analyses to address different issues, different types of upgrades, and there was no requirement to do that. Did I answer your question?
They did point to a couple of places in the service, I think it was in the service agreement, that they understood to be a notation that they wouldn't owe anything. And do you know what I'm talking about?
Yeah, I don't have it right in front of me, but I believe when the service agreement said they wouldn't owe anything, that was for new upgrades.
Right. That was my question,
Yeah.
is that was a statement that would be relevant to Z1,
Right.
not
exactly.
to Z2.
Yeah.
And then there was a subsequent notification right below that that said, with respect to existing upgrades, you might owe something.
Right. Yeah.
That's how SPP does it?
Yeah.
Because
yeah.
they wouldn't know anything with respect to under Z1 because they weren't, for these purposes, in the possession of being the upgrade sponsor that's requesting.
Right. And if you look at their service agreements at the time that they were signed, or at the time since they were signed, they do list a number of, or at least in Southwestern Public Services case, they list a whole bunch of upgrades that are required. Those were required either under Z1 or those were upgrades that are already part of the SPP transmission system but weren't yet built, but their service was contingent on those going into service.
Mhm.
But there was no, up until 2017, there was no listing of attachment Z2 upgrades. So when the service agreements talk about, in shorthand, you don't owe anything, that is for attachment Z1, new facilities that are identified through that aggregate study process. That's all it is. And that's why the notations were included in the study report. That was just to provide all the information that we had available at the time. We could surmise that there were certain Z2 upgrades that may be impacted by their service. I mean, obviously something that's very close, proximately, or electrically close, is something that most likely, you're going to trigger a flow on that upgrade. So some of those were listed in the service, and not in the service agreement, rather in the study report. But we didn't put them in the service agreement because there was no certainty that those would actually be, and there's also no obligation to do so at the time. If I could just address, one more point. The counsel for Xcel pointed to the white paper and discussed how they didn't think the white paper was going to be used to implement attachment Z2. And they pointed to page 3, which is Joint Appendix 275, the last paragraph. I'd like to talk for a second about a couple paragraphs in this particular page. So they cite the last paragraph, but I'd like to go up to the first full paragraph. Very first sentence says the CPTF, which is the crediting process task force that put together the white paper, recommends that the reserve stacking system and the subsequent use rules be used to determine if the but-for conditions have been met. I don't see how the white paper could not have been clearer that the white paper was designed to implement the but-for requirement. So the idea that, oh, we didn't know when we voted for this that you were going to use it for this purpose, I don't see how they can make that claim credibly. With regard to their paragraph about where we do reference the N1 analysis, that relates to sponsored upgrades. And the reason why sponsored upgrades are treated differently is that they're unilateral. Somebody comes along and says, I want to build this, okay? At the time they want to build it, all SPP does is takes a look at the upgrade and says, okay, is this going to harm us? In which case you have to mitigate that harm. It doesn't necessarily become part of the SPP transmission system that SPP is going to use until there's a subsequent use. So at that point, that's why you would apply the N-1, because if someone else comes along and says, okay, I have this service, you would have to look at that upgrade individually to see if it is now creditable. And so that particular paragraph is actually implementing attachment Z2, find the right site here. Attachment Z2 section 1B, which is on appendix page 51 of our brief. Okay. B talks about sponsored upgrades not automatically being a creditable upgrade, nor are they automatically eligible. That's why we applied that separate test. So we weren't admitting there that, oh, N-1 can work for all of this. We were just distinguishing this particular type of upgrade that is I say unilateral, I mean, it's an elective upgrade. It's not something that SPP has determined is needed as part of its system. So that's why there's a difference there.
Okay. Make sure my colleagues don't have additional questions for you. Okay. Thank you, counsel.
Thank you very much.
We'll give petitioner's counsel the rebuttal. Mr. Lowell will give you 2 minutes.
Thank you, Your Honor. So in Old Dominion Electric Cooperative, this court explained that there was no equitable considerations that would permit waiver of the following doctrine. Now here we had a tariff that defined who was responsible for revenue credits. As is attachment Z2, it states that it is that service that could not be provided but for the creditable upgrade. We heard FERC solicitor talk about how it is a subsequent use test. As the subsequent use test is how we calculate the credits. The text states that the credits shall be based upon subsequent use. And then above that, it defines who will be responsible by defining the universe of people who will be on the hook, pay a credit based upon such. There was some discussion about the rule of reason. As you know, that rule of reason requires that any practice significantly affects rates, that it must be put on file under Section 205. Here, I don't think there can be any question that the white paper significantly affected rates. FERC had to look to it to figure out what the tariff meant. So it should be quite clear that it should have been filed if it was going to be used to determine rates for us. Are there any other questions? I think that's all I was going to say.
I don't think so. Thank you, counsel. We'll give Ms. Kimmel her rebuttal time. Ms. Kimmel, you have 2 minutes.
Can you hear me now?
Yes, can hear you.
Okay, thank you. Turning to the question about the standard of review, I believe that the standard of review regarding a complaint addressing the filed rate doctrine would be that that was applied in the Old Dominion case. which I believe Ms. Spicella is correct that did FERC act arbitrarily and capriciously? Did FERC adequately or reasonably explain its decisions, which obviously we maintain that it did not. FERC's counsel said that I believe she said that everything that was relevant to the rates were filed at FERC, and obviously the white paper was not filed at FERC. The white paper is where the interpretation of how Z2 would be implemented that was not filed at FERC. Interveners included a citation in their brief to a FERC case, California ISO 147 FERC, paragraph 61-231, and that also includes the citation to the City of Cleveland case, which is 773 F. Second, I believe, 1368, talking about the rule of reason. The interpretation of the white paper did, as Mr. Lowell said, significantly affect rates, and without having been filed, cannot be considered part of the filed rate. And finally, in terms of the upgrades, there were, as I had mentioned before, a number of upgrades for which transmission customers have been charged that were just simply not put in the service agreements, and nothing in FERC's orders that we understood parsed out a differential as to whether it was a new upgrade or an enhancement. The fact is that we're being charged for upgrades that, as far as we understood, Z1 did require an obligation for SPP to notify us as to what those upgrades and charges would be. That didn't happen. It didn't make it into the service agreements, and so we maintain there was a violation of the filed rate doctrine. If there are any other questions.
I don't think so. Thank you, counsel. Thank you to all counsel. We'll take this case under submission. Can we just take a two-minute break?
Stand, please. This honorable court is again in session. Be seated, please. Case number 22-7127. Peter Toren, executor of the estate of David Toren, appellant, versus Federal Republic of Germany. Mr. Orsak for the appellant, Mr. Dirks for the appellee.
Good morning, counsel. Mr. Orsic, please proceed when you're ready.
Good morning. Thank you, Your Honor. May it please the court. I'm Gary Orsak for plaintiff appellant Peter Toren. The expropriation exception in the Foreign Sovereign Immunities Act confers jurisdiction over a claim that property was taken in violation of international law. In Philip, the Supreme Court held that the exception's reference to international law means the international law of expropriation or property, not human rights law, and it therefore incorporates the domestic takings rule. And because the plaintiffs in that case had as their principal theory of jurisdiction that the taking of their property was a genocide, the Supreme Court reversed and remanded. But the Supreme Court directed the district court to consider on remand an alternative theory of jurisdiction, which was that the plaintiff's claim was not barred by the domestic takings rule because the plaintiffs, despite having been born in Germany and living in Frankfurt at the time of the taking, nevertheless were not German nationals at the time of the taking. In light of Philip, Judge Leon dismissed our case for lack of jurisdiction, but that ruling was in error, and Germany's efforts to prop up the ruling are unpersuasive. Judge Leon dismissed the case first by mischaracterizing the essential theory of jurisdiction that we pleaded, and second, by misreading Philip. First, as he saw it, and as he wrote, the thrust of our theory of jurisdiction was that Germany, during the course of a genocidal course of conduct, sufficiently persecuted its Jewish nationals so as to render them stateless. And second, he held that the Supreme Court in Philip, quote, made clear that a claim like that one is not encompassed within the expropriation exception.
Mr. Orsak, assume that I agree with your argument that Mr. Friedman was stateless. What is your best affirmative evidence that a stateless, like the seizing of a stateless person's property, is cognizable under international law?
Thank you. I was going to get to it. I'll address it now. First, I should note, Judge Leon did not reach that question. He stated in a footnote that he didn't need to reach it. But I think the law ought to be pretty clear on this. First, in Philip, the court said, quoting section 185 of the second restatement, which was the version of the restatement in force at the time of the passage of the FSIA, that a taking of property violates international law when a state deprives an alien of property. The restatement goes on to say in section 171 that an alien is any person who, quote, is not a national of the respondent state. And comment G to 171 says, quote, a stateless person comes within the definition of an alien for these purposes. So my first part of the answer is that according to the restatement relied upon or at least cited to by the court in Philip, a stateless person is an alien. A taking from an alien is a violation of international law. But if I may add to that, the restatement is simply a reflection of what international law provided at the time. As we cited in our brief, United Nations Convention on Statelessness from 1954 specifically affords stateless persons, quote, treatment as favorable as possible, and in any event, not less favorable than that accorded to aliens generally.
So is your general view then that, I mean, typically with international law, the classic offense was by one state against another state, and it could be visited on a national of the other state, but usually it was an offense by one state against another state, and so you'd have a state-to-state conflict, and that would get worked out through diplomacy. And is your view that a stateless person should always be just considered for those purposes as if they were the citizen of another state, some other state? We don't know which state because they're stateless, but they should be considered the citizen of some other state such that it gives rise to a cognizable offense under international law.
I don't know that you have to accept that theory to conclude that a taking from a stateless person violates international law, which is to say you need to assume that a stateless person is in effect a foreign national. What I'm saying is that the law at the time said that the rights of a stateless person are as favorable as the rights of a foreign national, such that a taking from that stateless person, notwithstanding the body of law that Your Honor just referred to, violates international law. And I should add that while the court in Philip recited some of the history deriving from the law of nations and up through the what we now call international law, for the proposition that traditionally the law of nations contemplated affronts by one nation against another nation. And but if the court in Philip had concluded that a taking from a stateless person does not violate international law, it simply would have dismissed the case because the plaintiffs in Philip were Germans. They were born in Germany. They lived in Frankfurt. It would have been simple for the Supreme Court to say, in that circumstance, there is no violation of international law. Instead, it remanded with clear instructions to consider whether those individuals were nevertheless non-nationals, in other words, states.
Can I ask you about the restatement third? So
Yes.
I know that it postdates, but just in terms of the principles in the restatement third. So they define the taking that's actionable as a taking by the state of the property of a national of another state.
Yes.
And
Yes, I agree. That's what it says. But I cite you to what the Supreme Court said in Philip, which was that according to consistent Supreme Court practice, it refers for purposes of determining international law to the international law that was in effect in 1976 when the Foreign Sovereign Immunities Act.
so under the restatement third, you would be out of luck.
I agree with that.
Okay.
I agree. If you follow what you just read, that's the case.
And then there's the comment in 713 that specifically says that stateless people
I
can't assert the claim. That's just-
I don't dispute that the restatement third differs in that respect from the second restatement, but as all I can say is the Supreme Court said you don't follow the third restatement, you follow the second restatement, and that's what it cited to in Philip.
But is there a distinction that we need to make between whether the statelessness occurs by de jure statelessness versus de facto statelessness?
Yes, thank you, Judge Child. We argue both. We say that Mr. Friedman was rendered de jure and de facto statelessness. I think we're right on both, but our stronger argument is on the de jure prong, and that is because there have been courts that have said if the court needs to sit at the motion to dismiss stage and must determine, as a matter of fact, whether the violence done to the individual, the deprivations done to the individual are so severe as to render him de facto a non-national or a non-citizen, then we're sitting as a war tribunal. I think that's overstated, but our case doesn't call upon the court to consider any of that because Nazi Germany formally, unmistakably, legalistically rendered Mr. Friedman a non-citizen, a non-national, and stateless. It did so in 1935 by the first degree issued pursuant to the Right Citizenship Law, declaring that Jews are non-citizens of the right. Judge Collar-Catelli observed this same proposition. But more to the point, and I want to emphasize the legalistic nature of this once again, Nazi Germany declared Mr. Friedman an enemy of the state. We attached that declaration as Exhibit D to the complaint, and it did so specifically to provide a legal fig leaf to steal all of his property. So regardless what the status of all German Jews was under German law at the time, I think it's clear that they were rendered non-citizens and non-nationals. Mr. Friedman certainly was rendered a non-citizen and non-national, and that happened prior to the looting of his property. So,
And what international law of property are you professing?
the international law of property is international takings law, and so the law, as the Supreme Court held in Philip, international law is that a taking from an alien, at least according to the restatement, without just compensation or without an adequate public purpose, violates international law. So we're citing emphatically the international law of property.
And then when was this particular art taken? I don't know that you specifically alleged a time period.
We did. So the art was taken in 1941. And then there were securities that the family owned that were taken, I think, in stages, but we've alleged in the complaint, and we've attached, once again, exhibits to show this. Exhibits G and H, and then K through L demonstrate that in 1943 and 1944, subsequent to the Reich Citizenship Law and the declaration that Mr. Friedman was an enemy of the state, securities were stolen. And I would like to mention, even though it doesn't go directly to the jurisdictional point, this is an extraordinary Nazi looted art case. I realize there have been several before the court, because in this instance, we have a contemporaneous inventory created by the Nazis of everything that was stolen. We have the orders back and forth from where Mr. Friedman lived to Berlin, ordering the confiscation of the material. We also have records demonstrating that the intent after looting the property was to sell it. We have documentation attached to the complaint that the purpose was to liquidate these stolen items and mix the proceeds with Germany's bank accounts, which goes to your Honor, Judge Srinivasan's holding in Simon 1, that the commingling is sufficient to demonstrate the commercial nexus with commercial activity in the United States.
Can I ask you about the Phillips effect on Simon 1 and the restatement second, just to follow up on that, because we dealt with the restatement third, and we get back to the restatement second, which is operative for your purposes. So under section 175 of the restatement second says that the responsibility of a state under international law for an injury to an alien cannot be invoked directly by the alien. And we'll just assume for these purposes that an alien includes a stateless person.
Right.
Against the state, except as provided by the law of the state, international agreement, or agreement between the state and the alien.
Yes.
And your theory of qualifying under that is?
Yes, and Judge Childs, I attended the argument on the Simon and Philip remand last month, and the same questions arose. The question under the Foreign Sovereign Immunities Act is whether the taking violated international law. And 175 and comment D makes clear that it does. What you're raising are, as the restatement describes it, questions of standing to pursue the relief. And I think 175 is not the only place. I think it appears in 171 also, and it raises questions about how a stateless person would avail him or herself of legal redress for what it concedes is a violation of international law. That's irrelevant for present purposes.
You just think the FSIA?
We have the FSIA, and the FSIA says, here's your venue to vindicate your rights, but we need a hook in international law. The restatement says there's a violation of international law. So the qualification, and Judge Pillard was pressing on this question last month as well, it's simply not a relevant point because we're proceeding under the Foreign Sovereign Immunities Act.
And can I ask just about the role of genocide in your theory, because that's come up in the district court opinions, including in this case. And as I understand your theory, it may be that the genocide is factually germane because it's what resulted under your allegations in statelessness, but you're not actually resting your theory on proving a genocide or on the international law consequences of a genocide. It's just factually what happened is because of the treatment of Jews, they were rendered stateless.
Respectfully, not exactly.
Okay.
So we have two different theories. One is, and the one that I principally press here, is the de jure rendering of statelessness, which I won't say it has nothing to do with the genocide because it is hard to imagine that the government would have enacted these laws but for the fact that it was persecuting the Jews. But to illustrate the distinction, suppose a more benign Nazi Germany had enacted laws to strip the Jews of citizenship, but then didn't go about exterminating. It just treated them poorly. Under our de jure theory, the taking from any such Jewish individual would have been a violation of international law. We also say that there's been a de facto stripping of Mr. Friedman's citizenship because someone who's subject or a people that is subject to a genocide cannot be deemed citizens or nationals of the offending state. For that prong of our argument, we do rest on the genocide. And as I said earlier, I think that argument's right because all Philip said is we look to the international law of property, not the international law of human rights. And under the international law of property, unless you're a domestic, unless the victim is a domestic, such that the domestic takings rule shields the state from jurisdiction, you have a violation of international law. But I concede that is a harder call in the wake of Philip. Our de jure theory is not
under de facto theory, the violation of international law is what?
It is a taking from a stateless person. It is simply that person has been rendered stateless de facto because of the genocide. You cannot.
Right, but the violation of international law is not genocide.
It's not.
Right.
Under none of our theories, we read Philip, under none of our theories is a violation of international law, the law of genocide or human rights. It is simply the distinction is how was our client or our client's forebearer
rendered stateless.
That's the distinction. I see him.
I mean, if you could just, so one question really is whether a stateless person is more like a domestic national or more like an alien, I think, for the purposes of the domestic exception. And I'm not sure that the second restatement is entirely clear about that. I mean, if you can just point me to where you really think, the taking of property from a stateless person is contrary to international law.
I have a textual answer, and then I have what I think is the logical reason why that is the case. The textual answer is that the second restatement says in so many words that the taking by a state of property of an alien, I'm reading section 185, is wrongful under international law. And then the restatement second goes on to say, section 171, comment G, a stateless person comes within the definition of alien.
Well, but it says it comes within the definition of alien in this section.
Yes. Yes.
And does that section include 185?
I think it does. I don't understand any respect in which it would not. I think it does. But let me give the more logical answer that flows from Philip that I think provides color to this. Philip was concerned with the scope of the domestic takings rule, the premise of which is explained in the Belmont case from 1937 that Philip cited to. And it essentially says that a citizen or a national of a particular state, if that person is harmed by the actions of that state, should look to that state for redress. That's the premise of the domestic takings rule. It has also been explained pursuant to the rationale that you mentioned, Judge Srinivasan, which is that an offense against your own national is not an offense against another state. But in this instance, there is no way to apply the domestic takings rule or the rationale of the domestic takings rule because Mr. Friedman was not a domestic. He was stripped of his citizenship and of his nationality. And so what the question boils down to is if there's a taking in violation of international law and Germany doesn't have an escape hatch to jurisdiction under the FSIA because of the domestic takings rule, then his descendant has a right to pursue the claim under the Foreign Sovereign Immunity.
One more question. Is there any space between being stripped of your citizenship and being stripped of your nationality? So Germany seems to argue that even if the citizenship was legally taken away, that Mr. Friedman still remained a national of Germany. I mean, is there any space between those two things in international law or otherwise?
The law, in terms of case law in federal courts in the United States and also in international bodies, is pretty thin. I will observe that the Supreme Court in Philip used the two terms interchangeably. It said that a taking from a citizen is shielded by the domestic takings doctrine. In other places, it used the word national. We've cited scholarship in our opening brief, and I think more so in our reply brief, that scholars and historians agree that any distinction between those two terms is, to use their words, vanishingly small. And I have not seen an articulation for purposes of the FSIA or the domestic takings rule. I understand Germany makes that argument, but I don't think there's a basis for that. And in any event, our allegations, I think, are sufficient to show that he was stripped of both. The strongest evidence of that is that he was declared an enemy of the state, the purpose of which was to denaturalize him so that Germany had a fig leaf to steal his property. The last thing I want to say, if I may, one more second. You know what, if you want me to sit. So
if it's 1 second, it's up to you. We will give you a little bit of rebuttal time.
Thank you, Your Honor. We urge that if you agree with us that Judge Leon was wrong, that you remand with instructions to deny the motion to dismiss because this extraordinary case was filed 7 years ago, and the alternative grounds for affirmance that Germany raises all have now been thoroughly briefed. Judge Leon didn't reach them, but if the case is simply remanded on this issue, I fear that we will face years and years of additional district court litigation because of the state's right to an interlocutor.
Okay. Thank you, counsel. Let's hear from Appellee's counsel now. Mr. Dirks.
Thank you for pronouncing my last name correctly. I have a lot of problems with that, as a lot of people do. So I'm not going to give you a highlight reel of my argument in our briefs. They've been thoroughly briefed by both sides. You've got a tremendous amount of information to work with. A main point here is that what you're hearing is basically a repackaging of a failed genocide argument, trying to crowbar it into the law of takings post-Philip. We've talked in the briefs, our brief at pages 24 to 28 about the de jure, denationalization or not. We covered the de facto in 29 to 33. I prefer not to rehash that and get into some more important things, which has been talked about here and also in the Philip and in the Hungary cases 2 weeks ago. And that is, if someone is stateless, let's spot them at the purposes of argument. What's the result? And when you're talking about a violation of international law, it'd be useful to go back and think about what happened when the Helmrich case got remanded to this circuit. And they were struggling with, what's international law? And they, by and by, along in the brief, they say the plaintiff has an obligation, has to prove that, in fact, whatever the exception they're relying on has crystallized into an international norm that bears the heft of international law. And also talked about ambiguity. If it's ambiguous or uncertain, it's not there. It's got to be pretty darn clear. And I think that the fact that we're having this extended discussion about what happens if someone's stateless tells you that perhaps it's not as clear as the
I don't know. I mean, I think every time there's litigation in a case, people have arguments about what the law is.
Correct.
So
But
it turns on what is the answer? What is the state of international law at the relevant time about whether stateless persons are covered by can I just finish? Are covered by the prohibition against expropriations, because they're either, if they're more like citizens of the state that perpetrated the taking, they're not covered. If they're more like persons who are citizen of another state, they are covered. Citizen or national of another state, they are covered. And we've heard argument on why, under the restatement second, which is the one that is from the relevant time frame, we should consider them to be covered. But you obviously disagree.
I obviously disagree, and I think that the point has been made that the second restatement is perhaps not as clear as the appellants would like it to be. If you look at the third restatement, one of the things the third restatement says with regard to...
But I think counsel, unless you're going to tell us something different, I think counsel on the other side already agrees that under the third restatement, there's no claim.
Well, except that there's a comment here that in section 713 of the third restatement, it says that the third restatement in section 711 and 712, which are where the rubber meets the road, the principles in those sections provide no protection to a stateless person. But then if you look at in 712, it says that they were really restating the traditional rules of international law of expropriation of alien properties and take essentially the same substantive positions as the previous restatement. So the third restatement's statements are saying, hey, we haven't changed a thing. We're just telling you what the second restatement says.
Well, let's just focus on the text of the second restatement, though. I mean, what the third restatement interprets the second restatement to say isn't necessarily
It says that
So how would you distinguish the arguments about the second restatement itself, just on the text of the second restatement?
I don't think the second restatement supports their position, and I think the third restatement's.
Well, why does the second restatement?
Because it doesn't. The whole principle. If you go back to what the Philip case talked about, the whole principle of the law of expropriation in international law is that the taking of it's an injury to the alien's nation of sovereignty. You know, it's the injury isn't to the individual, it is to the individual sovereign.
Well, but the second restatement says that a stateless person comes within the definition of alien. So let's focus on the text of the second restatement. And why do you think that doesn't cover the argument that was made by your friends on the other
I
side?
think the nicest thing you can say about it is it's ambiguous.
What's ambiguous?
It's ambiguous in terms of you have to put it in the context of the international law that at the time, and even through the third restatement, where the injury is to the alien sovereign. We're talking about international law. We're not talking about the law of, of individuals having rights. We're talking about nations having rights.
I understand the conceptual distinction and the traditional understanding of international law, but I'm interested in this language in section 171 of the second restatement.
Mm-hmm. Well, it says it's an alien, but it doesn't say what that means in the context of other parts of the restatement. And what you see in the third restatement is where they lay it out for you and say, we're laying out for you here in the third restatement is what the second restatement says. We're not changing a thing in this area of the international law of expropriation.
So your theory, it has to be, if we let's just for argument purposes, I know you're resisting it, but let's just say we're not going to consider the third restatement.
Okay.
Let's just take it out of our minds for right now.
Okay.
Just under the second restatement alone, your theory is that even though the second restatement defines alien to include a stateless person in 171, we shouldn't assume that that definition governs in 185.
Correct. I think that the nicest thing you can say is it's ambiguous. And if you go back to what...
Because if it does govern, would you agree that if 171's definition does govern for 175, then on this theory, you lose?
Well, I think you have to put it in the broader context of the international law of expropriation, which was explained in Philip, is the theory is that it's the injury to the alien state. A stateless person doesn't have a state to be injured by.
Philip leaves open the question of whether a stateless person is more like an alien or like a domestic citizen or national. That's why they remanded that question in Philip. So it says nothing one way or the other about, which way how a stateless person should be conceptualized in this framework.
That's correct. And that's my point. If you go to what this court said in the remand in Helmreich, it says, well, if a plaintiff is asserting a violation of international law, it has to be not ambiguous. It has to be certain. And you get down to, also said, has to demonstrate that, in fact, it is crystallized into an international norm that bears the heft of international law. There's only one United States case that I'm aware of that dealt directly with that, and we cited, and it's the 11th Circuit case that said, stateless person,
But there's a difference between arguing that that the appellants here have failed to demonstrate this is covered by international law and arguing that a stateless person is not covered by the international law of expropriation. I mean, those are two distinct arguments. One is that they failed in their burden of proof, and the other is that international law forecloses a stateless person from relying on this law of expropriation. I mean, those are distinct arguments.
I understand it, but I think the burden is on the plaintiff to show that it is in fact covered. And once again, going back to Helmreich on remand, that's what this court said. If it's ambiguous, the plaintiff's out of luck. It has to be crystallized into an international norm. And the fact that we've had this discussion here, and there was discussion in the Philp case and in the Hungary cases that Judge Childs was at, the fact that we're having this extended discussion tells you everything you need to know about whether this is crystallized into an international norm and it's not ambiguous. So I think that's a problem. But I'd like to move on and talk about some other
Do you
things.
agree on the first part about de jure statelessness?
I'm sorry, what?
Do you agree on de jure statelessness? And then you just
No, as I said in our brief on pages
property?
24 to 28, we demonstrate that no matter how shabbily and reprehensible the conduct was, it didn't rise to the level of depriving him of his de jure nationality as German.
But what about depriving them of citizenship? Do you deny that Mr. Friedman was stripped of his citizenship?
He was stripped of a lot of rights. Okay? There are a lot of cases where people, for want of a better word, are second-class citizens. I think the thing is that the international law uses the term national. And I think they use the term national because what I didn't realize was until after World War II, citizens of the United Kingdom were not citizens of the United Kingdom. They were subjects of the crown. So in a lot of places, you could be a national. Everybody understands national, more or less. But citizenship wanders all over the place. And I think that's why the restatement talks in terms of national, because citizenship gets you into murky territory that wanders around all over the place, where nationality is more of sort of the international norm.
So a person, though, who is stripped of their citizenship by law, I think it seems like Germany's view of that is, although it seems that by law they were stripped of their citizenship, they somehow, Mr. Friedman, remained a national of the German state. Is that your argument?
No, I think we're saying that he, as reprehensible as the treatment was, it did not rise to the level where he was no longer a citizen and no longer a national. He didn't have the same level of rights as some other Germans did, but that didn't mean he was no longer, a German citizen or a German national. He just didn't have the same rights.
Did he have any rights after those laws were enacted and he was declared an enemy of the state? I mean,
Well,
I'm not sure how a declaration that someone is the enemy of a state could be consistent with the idea that they remain a citizen and a national of that state.
Well, obviously, I think we disagree with you on that, Your Honor. I think our brief goes over this in great detail. Yeah, I'd like to move on to some other things if it's possible. There are other problems with the case here that I think can't get lost in the shuffle. And that is one we talked in Helmrich about how in Helmrich the standard really changed to how you're supposed to review these things. They're relying on a plausibility standard, and I think that
This is on the commercial. This is that where you're going to now?
correct.
Yeah, and so the district court can get into any of this, right?
That's correct.
Yeah.
But I think that these are all alternative grounds, and I think we need to.
Yeah, I just want to see if my colleagues are interested in this, because I think we're focused on the parts of the argument that we've been talking about so far.
Correct.
And on that, I just want to make sure I understand your theory. So 171 says a stateless person comes within the definition of alien in this section.
Mhm.
But responsibility for injury too, and then goes on and says what it says about 175. And I know that part of your argument is you have to consider the entirety of the second restatement against the backdrop of international law, which deals in the realm of state-to-state
Correct.
disagreements.
Which Phillips even talks about.
Yeah, yes, Phillips does. Let's just suppose, I'm just trying to understand under the terms of the second restatement itself. Let's just assume the second restatement is a statute, and I'm just trying to understand this statute. I know it's not, but let's just pretend that it is. What's your argument that under the terms of the restatement, the theory that the appellant has put forth doesn't work under the terms of the second restatement? Because it just seems like a mathematical equation. The takings prohibition speaks in terms of an action against an alien, and then the restatement defines an alien to include a stateless person. Ergo, it works.
I think once again you have to put it into the context.
Okay, so your argument relies on the context, which is a perfectly fair argument.
Okay.
I just want to make sure that I understood.
Okay.
You don't
Sure.
have something under the terms of the restatement.
Right.
So
Okay, I understand.
let me ask if my colleagues have any additional questions for you this time. Okay,
Okay,
thank you for your argument.
you understood my alternative arguments?
What's that?
I wanted to discuss the
Yes,
alternative.
and we have those from your briefs. We've taken
Okay.
stock of those. I mean, if you want to I will give you 1 minute to do
Okay. Great.
your alternate argument if you'd like, but
Sure.
let's keep it at that because we're focused on the questions
Actually,
that we've been asking for.
something that was admitted in the reply brief is important here. What Mr. Toren's counsel said was that basically their allegations with regard to commingling are basically mirror of what the allegations were in Simon. And because it worked in Simon, it ought to work here. But putting aside the plausibility issue, which we briefed, and which the Second Circuit adopted in Recuro, the context of Simon was where Hungary did not contest the allegations. All the court had before it was allegations and arguments by the government of Hungary. We didn't do that here. we put in historical facts which demonstrate clearly that there is no plausible way that cash from 1942 could wind up in the United States in the 21st century as German property. And that the most important of which is that there wasn't no German government for 4.5 years. Germany was controlled by the 4 occupying powers for an entire period. So even if something managed to survive until May of 1945, to suggest that somehow or other, even though Germany didn't exist for 4.5 years, it wound up in the German treasury in the 21st century, this isn't plausible.
All right. Thank you, counsel. Appreciate your argument. Mr. Orsic, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. Judge Rao, I'd like to briefly come back to your question about Section 171 of the restatement. What you quoted to me was comment G, which says that a stateless person comes within the definition of alien in this section. That does refer to 171, this section, but if you look at the text of 171, the rule says a person is an alien for purposes of the responsibility of a state or injury to an alien. So that right there demonstrates that for purposes of 185, which is a question of the responsibility of a state or injury to an alien, because that's what it says, that's how I get from the comment in 171G to 185. You can't ignore the text of 171.
Well, 171 is just a definition section. So I mean, of course it applies because it's just defining what the term is. And to say that it's for purposes of this section, it would be pretty tautological to say it's a definition of a definition for purposes of a definition, but nowhere else. And
no, I agree. I'm saying it less artfully. My point is that 185 is the section I rely upon, and 185 must incorporate the definition of an alien. 171 is the definition of an alien, and 185 says a taking from an alien is a violation of international law.
So does that mean a stateless person is an alien throughout the restatement because it's in the general?
I think so. I haven't tried to do a study to determine whether there's a respect in which it can't be, but 171 says for purposes of the responsibility of a state, so at least for 185, it must. Because
185 states are responsibility of the state.
Correct. I would like the declaration of Mr. Friedman being an enemy of the state is in the joint appendix at page 95, JA 95, where the Gestapo makes that declaration. And we have cited law in our brief that says that the purpose of that declaration is to denaturalize an individual and thereby, under Nazi law, be able to steal his property. So I take issue with counsel's suggestion that we haven't demonstrated that the enemy of the state declaration was sufficient to deprive him of nationality. The last thing I'll say, and I realize you don't want to get much into the alternative argument, but this notion that the Helmrich case undermines and changes the burden of production we must make at the jurisdictional stage has been exactly that same argument has been rejected by 3 different post-Helmrich decisions by this court, Lambia, Schubarth, and EIC. And I'm happy to rest on our brief as to why the allegations we made of commingling are sufficient to allege the necessary doing commercial activity in the United States. I don't have anything to add to what we're saying.
okay. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 22-5263. Andrew F. Clyde, individually and in his official capacity as a member of the U.S. House of Representatives, et al., appellants, versus William J. Walker in his official capacity as Sergeant at Arms of the U.S. House of Representatives, and Catherine Spindor in her official capacity as Chief Administrative Officer of the U.S. House of Representatives. Mr. Cuccinelli for the appellant, Mr. Berry for the appellees.
Good morning. Good morning, council. I think I still have 1 minute to say good morning. Mr. Cuccinelli, please proceed when you're ready.
Apologies to the clerk. If I could reserve 2 minutes for rebuttal, I would appreciate it. I'm Ken Cuccinelli for the appellants in this matter. And that, as this court pointed out in Vanderjack in 1982, it's not the judiciary's role to tell Congress what rules they should adopt, but it is the judiciary's role to tell Congress what they cannot adopt or implement when those implementations are unconstitutional. The issue before this court is whether any constitutional protections may exist in the presence of the House's rulemaking power. The district court's dismissal of the case below effectively nullified the individual protections of the members under Article 1, Section 5, and under the 27th Amendment. And we'd respectfully suggest that this court should undertake 3 steps in overruling the district court below. First, with respect to subject matter jurisdiction, that it does exist, and I'll address that momentarily. That the speech or debate clause defense is inapplicable as a bar in this case, and to reach the merits of the case itself. A subject matter jurisdiction is interesting in the DC Circuit. It clearly exists in this case, but the nomenclature of this circuit has, with all due respect, been wrong for 50 years. This court's case law uses the word jurisdiction, but does speech or debate clause defense analysis, which is exactly what the district court did below. If the speech or debate clause were jurisdictional in the manner described frequently, at least in terms of the words used, the Supreme Court wouldn't have reached perhaps any of the speech or debate clause cases that
Mr.
they
Cuccinelli,
did.
are you asking this panel to overturn the precedent of the circuit, which is something that we lack the authority to do?
No, I'm not, Your Honor. If you want to keep using the word jurisdiction, that's fine. Kilborn uses the word defense. The Powell court helpfully listed the 6 arguments that they were going to address. One was subject matter jurisdiction. Another was the speech or debate clause. I would just point out that the district court here did what often happens is they said they were dismissing the case for jurisdictional grounds, but in fact did an analysis that is a speech or debate clause defense analysis.
So it doesn't have to be subject matter jurisdiction, right? I think our cases have used the term jurisdiction. I don't recall one that actually said subject matter jurisdiction. So if it's jurisdiction, that just means it's a thing that we address at the threshold. And if it's not subject matter jurisdiction, then it could be the type of jurisdictional argument like sovereign immunity or something that can be waived by failure to assert it. But here it's been asserted. And
It has been asserted. Yes.
we have cases that speak of it in jurisdictional terms, more than one decision. And so then it's an issue that we address at the threshold, whether the speech or debate immunity applies.
And so let me address that. The error in analysis of the district court below was in this speech or debate clause analysis, treating the acts at issue as somehow as it couldn't be separated from the passage of HR 73. Instead of dealing with it as analyzing the implementation of HR 73, acknowledging that the passage of HR 73 is entirely protected under the speech or debate clause. But the context, which is the word used by the district court below, that it relied upon to convert what it called on page 8 of its own order, administrative functions, into legislative acts, as that phrase is used in speech or debate clause analysis, was the context of being the subject of a House rule, the product of a House rule, the majoritarian power of the House to write its own rules.
Mr. Cuccinelli, you don't question that enacting a rule of proceeding is not within the jurisdiction of the House.
Correct. I do not.
And you are not alleging that this particular rule establishing security procedures is itself unconstitutional,
On its face, no. In implementation, it is.
but not on its face.
Correct. Yes. So HR 73 says nothing about magnetometers. It just refers to security.
But you don't think the
protocol.
use of magnetometers would be unconstitutional?
Well, it impeded members from voting, including Representative Clyde, one of the plaintiffs here. We cited others who couldn't vote because of how this rule was implemented, their most fundamental responsibility. And the fines were assessed for literally just walking onto the floor, which under no circumstance could reasonably be called disorderly behavior. And the problem that the House hasn't addressed is the elimination of the individual members' protections that are explicit in the Constitution. The disorderly behavior restriction is a restraint on the power of the House's ability to punish members and therefore to pass rules, not to pass the rules, but the nature of the rules has to respect that to punish a member requires disorderly behavior.
And you
That
think
didn't
that's a
happen.
standard that is susceptible to judicial determination?
Well, if it isn't susceptible to judicial determination, then it is left to the House to determine for itself. And that is a classic wolf guarding the sheep. That's the House just saying, trust us. And the court clearly reaches many speech or debate clause cases. And we believe that they should overrule the court below, reach this one, and address the merits that the actions to implement HR 73 were not legislative acts.
So sometimes implementation acts can be legislative acts.
Yes.
Obviously, sometimes they can be. And so the question is, where does this one fall? And the Supreme Court's language in Gravel says in deciding whether something counts as a legislative act, even though it's not core speech or debate, that it must be an integral part of the deliberative and communicative processes by which members participate in House proceedings. And so that you're not taking issue with the proposition that determining the conditions under which somebody goes on the House floor and who goes on the House floor is an integral part of the communicative processes, deliberative processes by which members participate in House proceedings. Your argument is that even if that's true, imposition of the fine and exaction of the fine is not. Is that my understanding your argument conceptually correctly?
Very close.
Okay.
So I would say that a security rule that in any way impedes the access of the members to the floor does trigger a constitutional problem. I mean, they're missing votes. So
You may have an argument on the merits about whether it triggers a constitutional problem. I guess what I'm trying to understand is it within the fold of speech or debate clause immunity?
Okay.
And on that, I didn't understand you to take issue with the proposition that having a rule about who can come on the floor and what conditions they come on the floor to engage in the deliberative and communicative processes by which members participate in House proceedings, because that's what happens on the floor. I didn't understand you to say that that filter was itself something that's outside of speech or debate immunity.
Correct.
So what you're focused
I don't
on
want
is
to overstate. Yes.
And what you're focused on is, even if that's within speech or debate immunity, the exaction of the fine as the consequence of violating the thing that we just said is within speech or debate immunity, that's outside of speech or debate. That's the way you're conceiving.
So on the former, what we call the doorkeeping role, is not a legislative act. So we would not concede that that is an intimate part of the legislative process. That doesn't suggest there can't be some security mechanism for accessing the floor, as does exist. However, that is not a legislative function done by members as members, to use some of the other court phrasing. And the payroll function is actually got a finding from the Third Circuit, a holding that it is not a legislative function.
So why didn't you challenge that then?
Well, we did.
I thought what you were challenging is the fine and the
extraction of the fine
right.
as well. Yes, under the 27th Amendment. I'm just not leaving aside the disorderly behavior protection for the members, and as if walking onto the floor is somehow disorderly or embarrassing to the House. If the House gets to define disorderly via passing a rule, then we've written the disorderly behavior protection out of the Constitution, out of Article 1, Section 5. Both have to be able to exist together, and that does, Your Honor, require a judicial description of what are those boundaries. It's describing those boundaries is the province of the court, and because these are not legislative acts of themselves, the doorkeeping function and the payroll function, this case should not have been dismissed, and it should have reached the merits. And by the way, I would note that addressing whether these acts are legislative is not a merits question. That is only, the merits question is only accessed by determining that they are not.
Right, deciding whether the legislative acts goes to speech or debate immunity,
Yes.
not to the ultimate merits of your claim. But so you don't think that determining the conditions under which members access the floor for purposes of engaging in I take it you at least agree that what members do on the floor is an integral part of the deliberative and communicative processes by which members participate in House proceedings.
Yes, I can't think of examples when I would not agree with that.
Right,
yes.
right. And so then determining the conditions under which members come onto the floor to do that, you don't think is an integral part of the deliberative and communicative processes by which members participate in House proceedings.
So this starts to get awfully close to the court's allowance for the House to make rules. It has no say in that, but to only step in when those rules in implementation somehow violate other constitutional rights, the language of Ballin and Vanderjack. And that's the situation here. The way this was implemented was impeding votes of members. It actively blocked people, including one of my 3 clients, from a vote, their most fundamental undertaking. And the sergeant at arms, the doorkeeper, applied the fine. The chief administrative officer collected the fine, but it was the sergeant at arms, the doorkeeper, who decided that the rule was broken, and the implication being, assuming there is a protection against being fined for disorderly behavior, that the member had committed disorderly behavior.
And so we have a case, Consumers Union, for example, which has to do with whether a press entity can get in the gallery of the House chamber. And we held that the enforcement of that rule, which prohibited the press entity from getting into the gallery, was within speech or debate immunity. So that case couldn't go forward. And this case is about whether a member can get to the floor. If there's speech or debate immunity for whether a press entity can get to the gallery of the floor, how is there not speech or debate immunity for whether a member can get to the floor?
So judging by your question, Your Honor, I would flip it around, that there is much more opportunity to control the access of non-members than of members, which is what was done in Consumers Union. And I would point out the members themselves personally made those decisions for the first 100 years of the House about which press got to access the floor. So when you think of what are things that members do as members, the Consumers Union case spells out the history that members did this. They clearly thought that press access to their proceedings was an intimate part of the legislative process, presumably because of the communication back and forth to constituents, but they were non-members. And when they were on the floor, they were lobbying members while legislation was under consideration. And so they were removed from the floor up to the gallery. And at a certain point, the Congress delegated the decision, because there are only so many seats, of deciding who may access that gallery to essentially a commission of non-members, but did maintain voting control over those decisions in a way that was not maintained with HR 73. So you have non-members who were literally lobbying on the floor in the midst of legislative consideration, who were removed from the floor. And speech or debate clause protection was provided because the context, which is what I feel like there's fourth judge here, Judge Ginsburg and Walker, analyzing Consumers Union, talked about this context and the atmosphere of legislation on the floor. But that atmosphere was with respect to non-members who were lobbying members on the floor.
But with non-members and members, I guess it seems to me, if we're talking not about the merits, but about speech or debate immunity, the fact that this case involves members seems like it more squarely implicates speech or debate immunity than less squarely implicates it, because it actually has to do with members on the floor as opposed to non-members in the gallery.
So the reason it is less applicable, one, is because I don't think anybody would dispute that House members have the right to access the floor that press members don't. This is the place where their job happens, where the legislating happens. So in that sense, there is, that's one removal of Consumers Union. Another is there are no member rights that press members have that my clients do. And that is not to be punished for behavior that isn't disorderly, even if they have to comply with certain requirements. There's no allegation that any other rule or any other requirements weren't in compliance by any of the members. And then they also, when the fines are removed from their pay, that varied their pay downward, it lowered their pay, contrary to the 27th Amendment. That's not a legislative act, the payroll function, as the Third Circuit held.
And are you indicating that we should analyze that separately, essentially the administration of the rule versus the enforcement of the rule?
Yes, Your Honor. Well, no, I'm sorry, I heard you wrong. The implementation of the two parts are the passage of the rule, which the House clearly has the power to pass rules, and this court and the Supreme Court have always made clear we're not going to invade the province of the House's rulemaking power. However, when rules that in implementation either violate other individual or constitutional rights or are illegal in some way, that portion of this chain of causation may be reviewed by the courts and has been repeatedly by this court and by the Supreme Court. That's what I meant, Your Honor.
Mr. Cuccinelli, though, if any time a member raises one of these arguments and then we decide that there's not speech or debate immunity, I mean, how would that not impact the independence of Congress as a separate branch?
So if I could bring three pieces together in answering that. One, I'd compare to the McCarthy case 2 years ago, where the act, again, skipping the voting to implement how they vote, but the implementation was about voting. I mean, it was about as intimate an element of the legislative process as you can get. Then you have the Ballin case that was about quorum, determining quorum and voting. So, those kinds of implementations of these truly legislative elements, I don't think the court could ever get into. However, where there are specific other protections, like the disorderly behavior protection, like the protection of unvaried salary, that if the court doesn't.
But your argument is that if there is like an invasion of the members' constitutional rights, and so, the way that members vote or, some of those questions, I mean, those could easily be recharacterized as invading the members' constitutional powers.
Well, and in the early 80s, the distribution.
And then those would be reviewable also by this court, which would be, in tension with this court's even very recent precedents.
I fully recognize the tension between the two branches, and which is also first and most respected by the courts, without exception, hands-off approach to the House passing rules and not sitting in judgment of any of them, ever. But again, how some of them do get enforced is another matter. And this feature debate clause is intended to maintain the independence you referenced, and perhaps more critically, to not have legislators bothered and taken from their legislative function by being dragged into court. And that's not who's here. That is not who we sued. We did not sue the speaker. We did not sue the members. We sued those who were implementing in a way that violated constitutional rights, House Rule 73. So we're respecting that difference. And it isn't that the court never has a role to play. We believe the court does have a role to play here, and that we're asking for a respectful resolution. By respectful, I mean respectful of the differences between the two branches, but also not allowing the writing out of individual protections, a la Ballin, from the Constitution that the members have a right to expect.
Sure, my colleagues don't have additional questions for you at this time. We'll hear from counsel of the House. Mr. Berry.
May it please the court. House Resolution 73 was controversial. Every member of the current House leadership voted against it, believing it to be misguided. And the security screening requirements contained in the resolution were not reimposed at the beginning of this Congress. But this case is not about the wisdom of House Resolution 73. Rather, it is primarily about whether appellant's suit is barred by the speech or debate clause, and then, if their suit is not precluded, whether the fines for violating the resolution run afoul of the 27th Amendment or the Constitution's discipline clause. And if I may turn to some of the points that my friend made, I think that the attempt to divorce the enforcement and administration of the resolution with the implementation or adoption of the resolution just is not consistent with precedent. As the Chief Judge pointed out in McCarthy in discussing the Consumers Union case, this court specifically said that the speech or debate clause applied to the administration and enforcement of rules governing seating in press galleries, not just the promulgation of them. And so too should be the case here, particularly in an instance where you're dealing with the regulation of member conduct and the members actually on the floor, not just in the gallery, which I think, as the Chief Judge indicated, is even more core to the legislative process. The second thing I would note is that—
But I think that there's an argument that it's, even if that's true, even if members on the floor are more core than non-members in the gallery, their argument is that voting is more core than exaction, than withdrawal of salary. And what's your response to that? Because I think you're right that per McCarthy and per other decisions, Consumers Union itself, and Gravel seems to presuppose that implementation definitely can be a legislative act. But the question becomes, is the implementation at issue a legislative?
And I think it is, Your Honor, because it's part of a scheme that regulates the very atmosphere in which lawmaking deliberation occurs. I also think it's a legislative act because it's part of a congressional discipline proceeding. In Rangel, this court said that a congressional discipline proceeding is a legislative matter that the Constitution places within the jurisdiction of the House. And what this court said in Rangel was the censure that was the end product, the execution of the disciplinary proceeding was not judicially reviewable. It was protected by the speech or debate clause. In this instance, it was not a censure that was the result of the disciplinary proceeding. It was a fine, but I don't see why the principle of the legislative act being an execution of a disciplinary proceeding would be the same.
The censure was promulgated by members?
It was, but there was the clerk had a role in actually implementing the censure and placing it, I believe, in the congressional practice. And so, but I think that what we're talking about here is not only a disciplinary proceeding, but a regulation of the very atmosphere in which lawmaking deliberations occur. And my friend has mentioned Ballin a number of times in the oral argument in the brief, but I think the key thing is that Ballin is not a speech or debate clause case. There was no congressional party that was a party to that case, and the speech or debate clause issue was never raised. So Ballin cannot speak to the issue of whether certain things are legislative acts and whether you look to the speech or debate clause first and decide that immunity question before you turn to the merits of whatever claim there is that the House rule is in violation of the Constitution. And I think with respect to the issue here, once you say that it's a legislative act, for instance, it does not matter whether we're talking about members or non-members. My learned friend says that while non-members are not being bothered, they're not being hauled into court. Members are not being bothered, not being hauled into court, and thus the purpose of the clause is satisfied if you're only suing non-members. But that is not consistent with this court's precedent. It's not consistent with what this court said in McCarthy. It's not consistent with Gravel, because part of the purpose is that the legislative branch as a whole, the legislature, should not be dragged into court and forced to deal with what can be a hostile judiciary. It's a separation of powers issue. And so the fact you're talking about officers of the House who are appointed by the Speaker versus members of the House, the distinction there is not relevant for purposes of the speech or debate clause in terms of what the underlying function of.
So you're, go ahead.
Mr. Ware, I was going to ask you, is there any circumstance in which, the House enacts a rule of proceeding and implements it, that a challenge to the rule or its implementation could be cognizable by this court? Are all rules of proceeding and all implementation of such rules beyond judicial cognizance?
Well, number one, I certainly don't think to win this case, the answer from that question has to be yes. And I'm not going to assert, given the scope of House rules, that there can never be a House rule, the implementation of which would not be covered by the speech or debate clause. I would concede the possibility there could be House rules that regulate things that are not do not fall within what we would consider legislative acts. But I think, again, here we have very specific case law on point in terms of the press gallery case, precedent about regulating the very atmosphere in which the deliberations of the Congress apply, the Rangel precedent in terms of congressional discipline being a matter that's within the jurisdiction of the legislature, the execution of that discipline not being covered. So the fact that there may be cases where you could challenge House rules and the speech or debate clause would not apply, I don't think means that in this.
Well, I take it under your argument, the House rules, I don't know how broad the House rules power ranges, but under the Supreme Court's precedents that we've adopted on the letter of our decisions, in order to fit within speech debate immunity, the matter at issue, meaning what's covered by the House rule, has to be an integral part of the deliberative and communicative process by which members participate in House proceedings.
Yes, and I think that there very well could be House rules that do not meet that test. For instance, if there's a House rule saying that there are going to be tacos served in the House cafeteria every Tuesday, I do not believe that we would claim that the execution of that would be protected by speech or debate clause.
Not even by someone who really wanted their tacos?
Excuse me?
Not even by a member who really wanted their tacos?
I mean, if they wanted a taco on Wednesday, no, but in more serious notes, something regulating that, for instess.
Well, we have a case, for example, with the
House restaurant
food service worker, and it's
I'm not claiming that there could be House rules, and there probably are House rules to which the legislative act test is not met. What I'm saying is, in this case, I very much believe, and precedent indicates, that the legislative act test is met.
This case doesn't indicate any boundary issue, is what you're suggesting.
Oh, no, I think it is. Again, we're talking about magnetometers that were placed directly outside the House chamber after January 6th. And I think that it regulates the very atmosphere in which the lawmaking deliberation.
So that might, I mean, I think there was some resistance to that too, but even if that does, the question is, does the consequence of not going through the magnetometer, i.e. the imposition of the fine and the exaction of the fine from the salary, is that integrally related to, is it an integral part of the communicative process by which members participate in House proceedings?
And I would say, Your Honor, pursuant to this court's precedent, the answer is yes, because the administration and enforcement of the press gallery access rules was deemed to be a legislative act protected by speech and debate clause immunity, and the execution of congressional discipline, whether it be by censure or a fine, is considered to be a matter that is within the jurisdiction of the House and was protected by speech or debate clause.
I mean, in Consumers Union, there wasn't the imposition of a fine. It was just that the entity that wanted to get in wasn't allowed to get in. And so from your view, if the consequence of trying to get in when you don't have the pass to get in is that you're subject to a fine, and then that entity tried to challenge the imposition of the fine, you'd still say that's a legislative act.
I would say that.
And that's
Absolutely. And if I know my time's running out, if I could briefly turn to the merits of the two claims here at issue. With respect to
We'll
this,
just make sure there's not additional questions on future debate immunity, because that was what the district court decision rested on.
Well, just whether or not we need to bifurcate the screening versus the fine.
right. Again, I think that the district court was correct that you're talking about a scheme regulating the behavior on the House chamber, and that the enforcement aspect of it is an integral part of the scheme. So I think the district court was right on that. And it's supported by the fact that in Consumers Union, this court did not distinguish between the promulgation of the rule, the administration of the rule, and the enforcement of the rule. They saw it also as a scheme, and the fact that this is a disciplinary proceeding, and the Rangel court decision teaches that the enforcement of the discipline, the implementation of the discipline is protected by the speech or debate clause. And I don't think the fact this is a fine versus a censure matters in terms of the protection that's given to the congressional discipline proceeding.
One follow-up question on that, and then we'll just give you a brief minute to talk about the merits. But Powell versus McCormick.
Mhm.
So that involved two measures that were implementation measures. One was withholding of the salary, and the other was the doorkeeper kept going into the chamber. And those, the Supreme Court said there was no speech or debate immunity. And so your distinction of that is?
Well, I would have three answers, Your Honor. The first is as a technical matter, it was the back pay issue that was not moot by the time that reached the court. But secondly, as Your Honor said in the McCarthy case, the best way to interpret Powell is that these were not legislative acts. I think the most logical way of looking at it is that the wholesale exclusion of a member from the body, meaning that they don't get paid, they're not considered to be a member. And one of the things is you don't get to go on the floor. The wholesale exclusion is not a legislative act. That's very different than a rule of general applicability, which regulates members' conduct and says that it doesn't stop you from getting on the floor, but if you go on the floor without going through security screening, you're going to get fined. I also think that there's certainly tension between the reasoning in Powell between members versus non-members and what came later in terms of Gravel and what's come later in terms of even this court's precedent, such as in McCarthy. And then just very briefly on disorderly behavior, I think that the dictionary definitions, whether it be at the time or now, give a definition of disorderly behavior as being contrary to the rules, contrary to law. And I think that the precedents indicate that the Congress has very broad discretion to define disorderly behavior. And if there's a rule that says you have to go get a security screening before going on the House floor, you don't go through the magnetometer, I think it is reasonable to say that that is not consistent with ordered behavior. If I show up to the airport and say I'm not going to go through the magnetometer at the checkpoint, I'm just going to walk around it, I don't think many people would say that that's ordered behavior. I think a reasonable person would say that's disorderly behavior. Second, with respect to the 27th Amendment issue, as I understand their brief, they're not challenging the imposition of the fine. They're saying the method of collection is unconstitutional. But we strongly believe that's not the case. They're given 90 days to pay the fine. If not, then it gets deducted from one's paycheck. There are many reasons why deductions are made from one's salary for the compensation for services. For instance, if you don't pay your child support, you can have your wages garnished, deducted from your salary. People don't say that if your wages are garnished for not paying child support, your salary, your compensation for services has been reduced. Your salary is the same, but some of it is just diverted for another purpose. Here, the salary, the compensation has not been changed, but some of it has been diverted for another purpose, which is paying the debt that they owe to the House because they haven't paid their fine. And there's a specific statute on the books that allows the House to collect debts through deductions from the paycheck. So, Your Honor, I think even if you get to the merits, the district court could still be affirmed. But I think pursuant to this court's decisions in Consumers Union, McCarthy, and Rangel, it is clear that these are legislative acts and that teacher debate clause immunity applies.
And just quickly, how long have fines been being deducted from salaries?
So the fines ended at the end of the last Congress. So the way they did it is they divided it up so that when the fines were imposed, a certain amount was taken out of paycheck so that the fine would be satisfied by the end. That's what happened with respect to then Congressman Gomer. Mm-hmm. Now, the other two appellants basically had almost their entire paycheck was being withheld for tax purposes. So all that could be done was that it could be deducted about $1 a pay period. So for Mr. Clyde and Mr. Smucker, they had to pay, I think, roughly about $18 in fines. That's all that the House was able to take. But they're not having deductions anymore because the ability to collect the fine ended at the end of the last fine.
And is that something the House has been doing over time? Fines being deducted from salaries?
So that has been, the statute allowing deductions for debt has been on the books for many, many years. And that is a way that has been, that this has been implemented. But it's also the case that the fines, the collection of the fines ends at the end of the Congress when the fine was imposed, because the House, unlike the Senate, is not a continuing body. The House Congress ends at the end of each Congress and completely reconstitutes itself at the beginning of the current Congress, as was rather dramatically portrayed at the beginning of this.
Mr. Berry, you said it was a statute that allows for the garnishment of fines, or is it?
There's a statute that allows for the deduction of debts owed to the House.
But it's a statute, not a
Yes,
rule.
and we did cite to it in our brief. Thank you.
Thank you, counsel. Mr. Cuccinelli, we'll give you the 2 minutes for rebuttal you asked for.
Thank you, Your Honor. First, I would start with the lack of general applicability of these fines. Even the child support example in Hatter is analogous with the judiciary 20 years ago. But these are fines directed to specific members taken specifically from their pay. And when you read HR 73, it was written to take it from the pay. Mr. Berry correctly described the financial results for my three clients, and it perfectly exemplifies one of the concerns of the founders in putting the 27th Amendment in and it having been passed. And that is that money not be able to be used to put pressure on members that would make a difference between poor men and rich men, then now women as well, being representatives in Congress. And here we have a real live example of it. I would also point out that in Powell, the exclusion of a member by the doorkeeper and the payroll deduction are about as close on point to the factual acts at issue here as you could find. Now, the court didn't go out of its way to make holdings specific to them, but implicitly the Supreme Court in Powell found both the doorkeeper function and the payroll function to be legislative acts. Otherwise, they could not have then reached the end of the case that they did. And recently we provided the court the Third Circuit case where it was an actual holding of the Third Circuit under speech or debate clause analysis, finding the payroll function in a Pennsylvania legislative subpoena case to be a legislative act. So that's the only holding that we're aware of, which is why we provided to the court. And thus, the lower court should be overruled on that basis. And just with respect to Rangel, I would note that the House went through its ordinary discipline process. The whole House voted on the censure. That was determined by the House to be disorderly behavior. That doesn't mean it automatically is under the Constitution, but that wasn't a basis on which it was challenged. And what was done there was a legislative act, the reading of a censure. There was no fine. Here, the power was delegated to the sergeant at arms in the doorkeeper function to essentially write a ticket. And he wrote a ticket to my three clients, one of them twice. And so they owe fines. There is not a vote of the House as there was in Rangel. The ethics committee that was sort of the appellate body was divided evenly on a partisan basis, 5-5. And so the majoritarian abuse that is the beginning of this case can't be addressed in an equally divided committee. And it was probably designed that way, but that's not for us to question here. it is for us to recognize that the process there was not an ordinary legislative process that relied on a majority vote to determine what had happened in each of these instances. Thank you all very much.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.